Right there. You got your phone off, right? Yeah. Well, told me and felt back talking about when I come to that
Is there any way that I could stay on the monitor for like a couple of weeks to get my affairs in line? I just got back to work. I'm gonna have to like go there and tell them what's going on and maybe help with it.
All rise. The Court of Common Pleas is now in session. The Honorable Eugene Lucci presiding.
May be seated. It's going to work out a little different. So, we'll talk about this.
These are case numbers 22 CR 000938 and 22 CR 000939. Both cases, State of Ohio versus John P. Andresco Jr. Mr. Andresco is in court, represented by counsel. Attorney Brent Urankar, representing the State of Ohio, as Assistant Prosecuting Attorney Lisa Naroda. The defendant was here on November 10th, 2022. With counsel, he pled guilty in the 938 case To count 3, possession of drugs, felony 5, a Division B offense, and a forfeiture specification. And in the 939 case, count 1, possession of dangerous drugs, felony 5, a Division B offense, and a forfeiture specification for contraband and instrumentalities. All remaining counts will be dismissed upon completion of sentencing. I refer the defendant for a pre-sentence investigation and report and set sentencing for today. I have received a pre-sentence report prepared by the Lake County Adult Probation Department dated November 18th, 2022. I've received a drug and alcohol evaluation with a brief mental assessment prepared by Dr. Rinsberg dated December 12th, 2022. I've received a sentencing brief filed on behalf of the defendant dated December 20th, 2022. And I've received a letter from NeoCap in reference to the defendant dated November 21st, 2022. I've read these documents. I will make them part of the record. Are there any inaccuracies or any modifications needed to any of the PSR documents?
None that I'm aware of.
Any reason not to proceed to sentencing at this time?
No.
You may address the court first.
Your Honor, at this time, Mr. Andrasco is requesting that he be placed on probation. Mr. Andrasco and I have been discussing this matter for some time. He's relayed to me numerous occasions that he has successfully completed probation previously. He fully expects to be able to successfully complete probation again. He does have a long and positive relationship with his assigned probation officer. He expects to take advantage of that relationship. Additionally, Your Honor, while he was incarcerated for 4 months on a probation violation out of Painesville Municipal Court, he reached out to Signature Health and began to receive services from them upon his release when he posted bail a couple of days ago. Your Honor, he's followed through. He's been attending his assessments. He's been attending his treatment. He's got a program worked out that he hopes to be able to complete. Additionally, he's obtained employment or regained his employment through Pet Processors, a job where he was earning $19 an hour, and he was able to help his family. Your Honor, his fiance is here today in the courtroom, is prepared to speak on his behalf. Your Honor, we understand that John does have a long and standing history involving drugs. In this case, there's a 2021 matter where he acquired Suboxone and a 2022 matter where he was fleeing from the warrant and was then subsequently arrested with vasodilators in his possession, a workout supplement. Your Honor, John's been working very, very diligently since 2021 to get off of drugs, to get himself clean and sober, and part of that end has been working out and maintaining his physical health. It's a way of helping him relieve his stress and anxiety and staying focused on the things that he needs to do. He understands that he was going about this in all the wrong ways. He is hopeful that he'll be able to address this in more legal ways because when I first began speaking with him, one of the things he indicated to me is that he was relieved that he was arrested because he no longer needed to look over his shoulder. And he no longer needed to worry about when or if he's going to get picked up because he never left the city of Mentor. He knew it was just a matter of time. He's in some ways relieved that he is here today taking responsibility for all this stuff and able to put all of this behind him. Your Honor, we're hopeful that this court will place him on probation, considering the fact that he served approximately 4 months in the Lake County Jail on a probation violation. He has reached out and begun treatment services. He has been doing well, to my understanding, since his release from the jail. We can trust that he's going to return, as evidenced by the fact that he's here today facing a sentence that, to be honest with you, Your Honor, he's terrified about right now, both for him and for his family, because financially he's not entirely sure Claire and her daughters will be able to do it without him. So, Your Honor, he is trying to do things the right way now. He is just asking that he has a chance on probation. My understanding now is that he's sick and tired of being sick and tired and just wants to make things better for himself and his family going forward. So with that, Your Honor, I'm going to ask his fiancée, Claire, to come up and make any statements that she wishes with the court's permission.
Yes.
State your name, spell your last name.
First name's Claire, last name's Corder, C-O-R-D-E-R. Sorry.
And how do you spell the Claire?
My first name, C-L-A-I-R-E.
And your relationship with Mr. Andresco?
His fiance.
And what do you want me to know?
I know what he did was not okay, and we both have, we've had long discussions about it, and I can speak to what I've seen over the past few years being with him. He works hard. He is a good man. He helps take care of me and my daughter. We live a normal life. We both go to work every day, Monday through Friday. We spend time with my family. We do normal, everyday things like everybody else, and I just ask that you please let him try to at least do the probation route and show you that he's changed and that he can continue to live the life we have been. Financially, the last 4 months have been very difficult on us, and I'm very worried about how we're going to continue if he is to have to be put away again. And I just ask for your leniency.
All right, thank you.
Thank you.
You may continue, Mr. Duranko.
Your Honor, so for those reasons, we're asking that the court place Mr. Andresco on probation, allow him to continue with his treatment at Signature Health, allow him to continue with his employment so that he can meet his financial needs, his treatment needs, and needs with his family and obligations to the court. Thank you.
John Andresco, the law allows you to say whatever it is you want me to consider before I sentence you. What do you want me to know?
I would just like you to know that this is all, I take responsibility for what had happened. I shouldn't have ran, but I was in a bad point in my life at that time where I would have turned myself in. I think I do good on probation and things like that when I have a little extra guidance. The last time I was on felony probation, I completed it. I never failed the drug test. I always showed up. I'm back in the Signature Health. I'm back at my job. I mean, my family needs me. And it would just be, I just was away for 4 months and it was like terrible. I've grown up a lot since my past record that you've probably read about. I mean, I've been off of drugs, serious drugs or anything like that for probably 7 years. I've never picked up cocaine, like a major drug, again, since I stopped doing it about 7 years ago. I really try hard. I don't look at anything lightly like I used to. Everything I do is serious, and it's like I just want to be normal and go to work like everyone else and take care of my family and help out. And I think that just having a chance on probation before I have to go and do any kind of time, I would really greatly appreciate it, and just to show the court and everyone else that I can follow through with things, and that's what I would like to do. But I understand whatever has to happen today will happen, but just please consider that I have a job, I have people that depend on me, and I don't really want to leave them behind. And I apologize for everything that has happened, and I just hope that I have a chance to be on probation and to show that I could be a productive member of society. Thank you.
Let me hear from the state.
Judge, as the state discussed in chambers with both defense counsel and the court, the state would join in the request for community control. However, the state would ask that the court impose the recommendations that have been previously discussed in chambers that involve jail time, drug treatment, and community time.
I've considered the record, the oral statements made, the pre-sentence report, drug and alcohol evaluation, letter from NeoCap, the sentencing brief by the defendant, my conference in chambers with counsel and probation, and the statements of the defendant and the defendant's counsel. I've also considered the overriding purposes of felony sentencing, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender and promote the effective rehabilitation of the offender using the minimum sanctions that the court determines accomplish those purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution, along with the public burden. I've considered the joint recommendation of the parties for a community control sanction. I have reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders, and including the sentence that I gave to the co-defendant. In using my discretion to determine the most effective way to comply with the purposes and principles of sentencing, I have considered all relevant factors, including the seriousness and the recidivism factors set forth in the code. There's a factor that makes the offenses more serious. The offenses were committed for hire or as part of an organized criminal activity. There are no factors making the offenses less serious in terms of recidivism. There are factors that make recidivism more likely. The offenses were committed while on probation with Painesville Municipal Court, so that the time that the defendant has been serving is attributable to the Painesville Municipal Court imposition of time for the probation violation. Defendant has a previous extensive criminal history and history of juvenile delinquency, which includes 5 prison commitments. I think, what, 3 numbers? 2 numbers?
I think it's 2 numbers.
2 numbers, 5 commitments. Lumping together, he has at least 8 convictions dealing with drug activity, 4 dealing with assault, 3 dealing with failing to comply, 5 dealing with either resisting or contempt of court or obstructing, 5 OVIs, 4 no operator's license or driving under suspension, and at least 8 probation violations that I counted. There has been a rehabilitation failure after previous convictions or delinquency adjudications, a failure to respond in the past to probation or community control. There is a pattern of substance abuse, and the offender refuses to acknowledge a problem or accept treatment or apply treatment tools previously given to him. In terms of factors making recidivism less likely, the defendant appears to have a stable home and family environment and employment. Under 2929.13B1, although these are 2 felony 5s, there is no presumption for community control because of the offenses being done as part of the criminal activity, organized criminal activity, and the prior prison terms, and that they were committed while on probation. The court, having considered everything that's been presented to me, will afford the defendant one last opportunity to prove to the court, his fiancée, and himself that he can lead a law-abiding life. The court will adopt the joint recommendation for a community control sanction. I'm imposing community control for 2 years on each count, concurrent, subject to the general supervision and control of the Lake County Adult Probation Department under such terms and conditions that it finds appropriate. Among these, you shall not leave the state of Ohio without the permission of this court, and you shall abide by all laws, including but not limited to all laws related to firearms, deadly weapons, and dangerous ordnance. The court further imposes the following specific sanctions and conditions. On the 938 case, count 3, 62 days in jail with credit for 2 days already served. The latter 30 days of which you shall enter, participate in, and successfully complete the jail treatment program and follow all aftercare recommendations. Immediately following your stay in the Lake County Jail, still on the 938 case, you are to enter, participate in, and successfully complete the Northeast Ohio Community Alternative Program, NEOCAP, and follow all aftercare recommendations. While there, you're to be supervised by the Trumbull County Adult Probation Department. Still on the 938 case, you're to be brought back to Lake County for an additional 60 days of transitional day reporting, which can be reduced or eliminated based upon stabilizing factors in your life, predominantly employment and home. On the 939 case, I'm imposing no jail time, and you have no jail time credit. So you understand, I'm saving that one. Should you screw this up, you'll get the full measure on the 939 case, 12 months. You understand that?
Good.
On all counts, you're to follow all the aftercare recommendations of the jail treatment program and NEOCAP, complete abstinence from alcohol and drugs of abuse, periodic screens to monitor your compliance, to attend a minimum of 2 12-step program meetings per week, have a sponsor, and be involved in a home group. You're to continue your treatment at Signature Health. You're to have full employment or school, combination of employment and school, but outside of any establishments that sell or purvey alcohol or drugs. You're to have 1 doctor, 1 dentist, 1 pharmacy at any one time prescribing or filling prescriptions for you. You're to inform the Adult Probation Department of any change of providers. You're to sign medical releases so that they can monitor drug-seeking activity on your part. You're to inform your providers of your addiction, not only to alcohol, but heroin. And I know the heroin's in remission. You're to take all medicines as prescribed, have no contact with the co-defendant. You're to forfeit all contraband and instrumentalities. All of the remaining counts are dismissed. You're to pay the costs of prosecution, confinement, community supervision, treatment, and court costs. The violation of this order will result in a prison term on each count of 12 months, with credit for time served, of course, consecutive for a total of 24 months, If you do end up in prison, post-release control is optional for a period of up to 2 years. They'll give you rules. If you violate their rules, they can return you to prison for up to 9 months for any one violation, subject to being returned to prison for up to 1/2 of the original prison term I give you at that time for all violations in the aggregate. All of that time is part of the sentence. Should the violation of post-release control be a new felony, the judge in the new felony case, in addition to sending you to prison on the new case, can send you back to prison on this case for the greater of 1 year or whatever length of time remains unexpired on that potential 2 years of PRC, and all of that time is part of the sentence. Should you end up in prison, you may be able to earn credit capped at 8% of time to be served or a certain number of days according to the regulations for engaging successfully in programming offered to you for that purpose. So long as you are not serving a prison term and you are on probation, you may be able to substitute community service to pay off the costs of prosecution, working them off at the rate of $10 per hour. Each hour of work performed reduces the judgment by that amount. Remind you, so long as you owe any court costs, I haven't fined you, so if you owe any court costs, the state can block your motor vehicle license plates until they are paid in full. Bond, if any, is released. Is there anything further from the state?
Nothing further.
Defense?
Your Honor, Mr. Andresco has just informed me that he would like to request a minimum term of prison in lieu of the NeoCat order. Thank you.
Mr. Andresco, why is that?
It's just like going through all these programs. Now, I'm not trying to say like I don't need them or I don't, I'm not refusing treatment, but I've been through all of these. I know what I need to do to stay sober and clean, and I've been through all that, and I've been sober and clean. I got caught with some Suboxone and some workout medication, but I just don't. I mean, those kind of places, being around, talking about drugs for months and months on end, and being around those kind of people again, I'm not downplaying it, but it's not for somebody where my head's at. Prison's not any better, but just all that treatment, talking about drugs every day, all day for months on end, and just being around, because a lot of those people in those programs, you can't get away from them in those places. They're not there really for the program. They're just there to get back out and go do what they used to do, like I used to do. So being in prison, you could avoid people. You don't have to talk to people. You don't have to involve yourself in that. There, I just feel like I would not fit in right there. I'm not trying to make a big deal or make myself look bad, which I probably am, but I just really, it's like a lot of things to do, a lot of drug treatment still. And for me, even when I did get out and I go back on the street and I go back to work and I go back to being, a regular person, I'm still going to be put in those positions of being around those people, and I don't do well in those settings with those types of people, having to involve myself with them on a daily basis. Maybe it's just me. I don't like, having it talking about doing drugs or how this happened or that happened. I'd rather I've been living for 7 years without having AA and stuff like that. I'm not saying it's bad, but for some people, maybe me, I don't like hearing about the drugs all day, every day. And I know how to stay sober. I've been sober for years, so I know it probably sounds bad, and I apologize, but I just hope you could understand my point of view.
Well, you understand that if I do give you prison, and when you get out, if you engage in substance abuse, you understand whatever judge has the case can take into consideration an outright rejection of treatment, and you'd likely get prison that time, probably a very stiff sentence.
Well, Your Honor, I really don't plan on ever getting in trouble again.
Most people don't plan on it, but it happens.
I mean, this time it was just, I mean, I take responsibility for it, but it was a couple Suboxone strips that they give to everyone. I could leave court today and go to Signature Health and say, hey, can I get Suboxone? And they'll say, sure, here, you could have it. You know, and then I had a workout supplement pill. And I'm going to do 10 months in jail for it, you know, because of my record. After I've done good for years, I hold a job, I have a family, I have a home. You know, I mean.
All right, have a seat. Just for the record, my sentence has not been finalized yet. I'm still in the same sentencing hearing. Nobody's left the courtroom. The record should reflect everybody's still seated where they were just a minute ago when I handed down a community control sentence. And taking into consideration what the defendant has said and adding it to everything else that I have found, court determines that the defendant's not amenable to an available community control sanction, and I am imposing 7 months each count concurrent, credit for 2 days on the 938, 0 days on the 939. The post-release control admonition I told you about just a few minutes ago applies equally. Does counsel waive my actually going through the whole post-release control admonition again?
We do waive that.
Anything else from the state?
No, Judge.
Defense?
Nothing further, thank you.
Probation?
No.
All rise. This Court of Common Pleas is now in session. The Honorable Eugene A. Lucci presides.
We're on the record. This is case number 17 CR 000515, State of Ohio versus Jonathan J. Stencil. Mr. Stencil is in court, represented by counsel, Attorney Brad Wolf. On behalf of the Lake County Adult Probation Department is Probation Officer Kim Randallson. The defendant was here on March 29th, 2018. With counsel, he waived indictment, pled guilty as charged. Count 1, grand theft, felony 4. I referred him for a pre-sentence investigation and report. I reset his bond at own recognizance. I sentenced the defendant on May 3rd, 2018 to 2 years of community control sanctions with 90 days in jail, credit for 2 days. With work release, he was to do an intensive outpatient treatment program and follow all recommendations in aftercare, abstinence, screens, 12-step program meetings, full employment or school, restitution of $1,000 to Victim Federal Hose Manufacturing, judgment rendered for that amount also to be paid in full. At least 90 days prior to the expiration of the stated period of community control. Gave him a payment plan, $50 per month. 1 doctor, 1 dentist, 1 pharmacy. Take all medicines as prescribed and other requirements. Told him a violation would result in a prison term of 18 months. I notified him of the potential and consequences for violation of post-release control. Explain the 8% credit, substituting community service for costs, and the state block on the motor vehicle registration. The defendant returned to the court on July 19th of 2018 on a probation violation. He waived his probable cause and final hearings, pled guilty to one violation, testing positive for methamphetamine, a non-technical violation. I extended his community control by 1 year to a total of 3 years and imposed 155 days in jail, credit for 80 days. He was to complete the jail treatment program and aftercare. All of the conditions remain in full force as previously ordered on May 3rd of 2018. I repeated the admonition for post-release control and that a violation would result in an 18-month prison sentence. The defendant returned to the court on December 13th of 2018 on another probation violation. He waived his probable cause and final hearings, pled guilty to testing positive for methamphetamine, a non-technical violation. I continued his community control for the 3-year period and imposed 114 days in jail, credit for 24 on the violation. Court noted that the overall credit as of that date was 179 days and ordered that he complete the Northeast Ohio Community Alternative Program, NeoCap, follow all aftercare recommendations, followed by 60 days of transitional day reporting, and either there or on the outside, complete the Thinking for a Change program. I reiterated that a violation would result in an 18-month prison sentence. I repeated the notification for post-release control. The defendant returned to the court on another probation violation on September 30th, 2019. He waived his probable cause and final hearings, pled guilty to testing positive for methamphetamine, a non-technical violation. I continued his community control for 3 years, imposed 45 days in jail, credit for 43. As of that date, the overall credit was 374 days. He was to do an intensive outpatient treatment program and aftercare. All of the conditions remain as previously ordered on May 3rd of 18, July 19th of 18, and December 13th of 18. I reiterated a violation would result in an 18-month prison sentence. I repeated the post-release control advisement. The defendant returns to the court on another set of probation violations. The probation violations are documented in affidavits signed by Officer Kim Randallson. She first alleges that the defendant tested positive on September 16th of 2020 for methamphetamine. And then she filed an addendum and says that the defendant failed to report on September 30th of 2020 and thereafter. That affidavit was signed October 22nd of 2020. The state of Ohio filed a motion to terminate community control. I've met with defense counsel and probation officer in chambers, and I am informed by your attorney that you wish to give up your right to a probable cause hearing, the purpose of which is for the court to determine whether there's a reason to continue to hold you to answer for the violations. He tells me you wish to give up your right to a final hearing whereby the court would require evidence to its satisfaction that you violated in either or both of the ways alleged in the officer's affidavits, and if I so find, you're entitled to a sentencing hearing. Do you understand these hearing rights?
Yes, Your Honor.
You understand your exposure is 18 months in prison minus the time served already? Yes. And have you discussed with your attorney the waiver of your probable cause hearing, the waiver of your final hearing, a plea of guilty to the 2 violations, and any other options you may have at this point?
Yes, Your Honor.
And has he answered all of your questions about that topic to your satisfaction?
Yes.
Do you give up the right to a probable cause hearing?
Yes.
you give up the right to a final hearing.
Yes, Your Honor.
What is your plea to the first violation, positive methamphetamine in violation of Rule 8?
Guilty.
And your plea to the second violation, failing to report in violation of Rule 3?
Guilty.
Court finds that the defendant has knowingly, voluntarily, and intelligently waived his rights to a probable cause and to a final hearing, has entered a plea of guilty to 2 violations. Court finds the defendant guilty of both violations and determines that they are both non-technical violations because they show an abandonment of the purposes of community control. Any reason not to proceed to sentencing at this time?
No, Your Honor.
You may address the court first.
Thank you. Good morning, Your Honor. And may it please the court as briefly as possible, submit that Mr. Stenzel is remorseful and accepting of his choices of conduct in this case. He is contrite for both the probation violation and the underlying offense, Your Honor. There are no excuses. The facts are not in dispute, but I submit they are important, as Your Honor has correctly recapped the history of John's probation violations. In 2018, he picked up the sentencing for the underlying case, as well as 2 additional, the first and second probation violations. Quite frankly, then he did good for a year, Your Honor. You didn't see him again until October 2019. He did good again, and his 4th probation violation wasn't until September of 2020. As I have discussed with Your Honor, John relapsed on this day, and it caused a dirty urine. The reason he relapsed was due to personal financial stress influenced by the pandemic. His family was evicted from the home with 2 days' notice, without providing any excuse whatsoever, Your Honor, but mere context as to why he relapsed. He then made the decision to stay out and not report to probation, while keeping in contact with them at some points, but nonetheless not addressing the underlying warrant, which we fully acknowledge today. As for the merits of the dirty urine, Your Honor, John will tell you that today is the 804th day of his sobriety. I have no way to verify that independently, but as an officer of the court, I'm simply conveying that my client claims that since October 20th, 2020, that was the last day that he used. As the court is aware, earlier in this case, in November, he was arrested in an unrelated matter at Paynesville. He was brought to the Lake County Jail, was very forthright about the warrant. They released him due to computer issues, I believe. He did get a call from the probation department. He made arrangements to turn himself back in immediately. John is here today with the support of many people in the courtroom, including his 3 children, his wife, his employer, many co-workers, and I would respectfully submit that John has a very strong support system when he is on the other side of this, Your Honor. And it's very sad because back in 2020, had he reported as required to do, he only had 5 months of probation at that point. This would have been done. I do know that John has prepared some remarks in the form of a letter. I'm happy to paraphrase or hand the letter to Your Honor. I believe he's done that in the past. The court has a preference.
I'll take it.
Okay, thank you, Jim.
Okay.
In conclusion, Your Honor, I would ask the court to take all of my comments into consideration. Respectfully, humbly request the court continue any term of community control sanction. I know that John is very much looking forward to the old saying, talk is cheap. And it's difficult to say that on the one hand because it has been 2 years, but on the other, I believe I can speak for John when I say that he's really turned a corner. And the last 37 days here have been quite impactful, especially over the holidays, Your Honor. With that, we're happy to answer any questions. Thank you.
Mr. Stencil, I have read your letter, page and a third. Do you have anything to add to that?
Just want to apologize to my family and the court. And I stayed out just to support my family. I just felt that was more important than my legal issues at the time. Even though it was probably the wrong decision, the decision that I made. And I apologize. And that's all.
So Kim, what's the credit on the violation? 37. And the overall credit? 113. That's included in the 37?
Yes, Your Honor.
You can be seated. I've considered the record, oral statements made, pre-sentence report, my conference in chambers with counsel and probation, and the statements of the defendant and the defendant's counsel. I've also considered the overriding purposes of felony sentencing, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender and promote the effective rehabilitation of the offender using the minimum sanctions that the court determines accomplish those purposes without imposing an unnecessary burden on state or local government resources. I've considered the need for incapacitation, deterrence, rehabilitation, and restitution, along with the public burden. I've considered the recommendations of the parties. I have reasonably calculated the sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society and the victim, and to be consistent with sentences imposed for similar crimes committed by similar offenders, and using my discretion to determine the most effective way to comply with the purposes and principles of sentencing. I've considered all relevant factors, including the seriousness and the recidivism factors set forth in the statute. You've paid restitution in full, correct?
Correct.
And you've paid all your supervision fees?
Correct.
And court costs? There's been no change in seriousness factors in terms of recidivism. This is yet another probation violation similar to the prior ones, the positive methamphetamine. I'm taking the defendant at his word that that was the last time that he used. And the failing to report has to be addressed and punished. And so I am terminating your community control and imposing 60 days in jail with credit for 37 days on the violation. Anything further?
No, Your Honor. Thank you.
All right. And Kim had a coughing spell, so I'm assuming that... Kim, anything further? You have no idea what I said, do you? All right. I'm terminating community control, imposing 60 days, credit for 37 on the violation. Anything further? All right. Good luck. We're adjourned.
Thank you, Judge.
Thank you.
maybe they don't want it. You have to see the second one,
You have the hearing, the thing for hearing.
Do I?
Hearing, yeah, please.
Ma'am, before you call it, the second one.
Oh, did you say that?
Yes, ma'am. It's okay, you got a lot going on in your mind.
Sorry about that.
That's what you do today, you'll be fine.
Maybe he said sit over there, but I didn't recall him saying where. Maybe they have an injury side. Thank you.
This is the volume right here, okay?
I heard that. Hey, Rhonda, say something. Say something. It must only work up there. Ooh. Okay, this is the microphone. I get it. Never mind, you're not by the microphone. Hello, hello? Hello, hello? There we go. Testing, testing. Yep. I hear white noise.
Set up with that ear thing again. Are you done with IOP?
Oh, yeah, I graduated IOP, and I'm not in the regular sober living house anymore. I'm paid for stay. I'm paying rent.
Okay. Okay.
So she's done with IOP?
Yep, she is. And she's paying to stay at the sober living house.
And I'm volunteering at the food bank, and I'm volunteering for Alcohol Anonymous's intergroup office. I'm on the ball. I'm taking my CDCA course.
I know, I told him that. No, Tom's
It might be in too loud. I can't.
Yeah, a little bit.
Oh, sorry.
It's okay. You're good.
Okay.
He's gonna come out in just a second. He'll be right out.
Which is great. Yeah.
Oh, shit.
Sure. What did,
I could have done my nails. That's how busy I've been. It's better than this. My rheumatoid arthritis is so bad I can't get my ring over my finger.
I wondered what he was doing up there.
That's from the rheumatoid. So I'm starting a new fashion trend. We call it fashion for rheumatoid. Like I have time. The food bank I volunteer for is called the Timothy Project, and they help males with housing and recovery and everything. They help females with recovery, but housing is just for the males right now. But I'm working in his clothing bank too. I'm a busy woman. And I started school Sunday. I tried calling you yesterday, but there was a holiday for you guys. So I'm like, I couldn't recall if I had told you about any of that.
You were able to tell me today. You were able to tell me today.
Wow, you speak really soft.
You told me today, so we're good.
Okay, all right. Yeah, I'm paid for stay with 3 employees who scored a 1. I still get drug tested. I don't even care about that. I love that because with every drug test I take, that's confirmation, and that keeps my granddaughter in my life quiet. I hear myself talk. It's overwhelming. Because of this, I have one granddaughter back, and I got invited to have a camp out Saturday with her in their living room because I'm allowed one overnight. And I'm doing that as long as they approve it. They have the administration has to approve it though. And I also get to meet my other granddaughter. I wasn't there for the first year of either one of their lives, so.
And whose kids are they? Whose kids are they?
My son Kyle.
Okay.
Yeah. My oldest boy didn't have children.
Didn't.
Although when I look at Ann Lee, I'm like, she did date him momentarily right before she was pregnant, but I don't.
All rise. This court of common pleas is now in session. The Honorable Eugene A. Lucci presiding. Please be seated.
For on the record, this is case number 22CR000648. State of Ohio versus Lori L. Abbey. Ms. Abbey is in court, represented by counsel. Assistant Public Defender Mary Springer, representing the State of Ohio, is Assistant Prosecuting Attorney Lawrence Geigrich. The defendant was here on October 12th, 2022. She waived indictment, pled guilty as charged. Count 1, aggravated possession of drugs, felony 3, with a presumption for prison. I referred her for a pre-sentence investigation and report set sentencing for today, and I continued her bond. I have received a pre-sentence report prepared by the Lake County Adult Probation Department dated December 28th, 2022. I've received a drug and alcohol evaluation with a brief mental assessment prepared by Dr. Rinsberg dated December 12th, 2022. I have read these documents. I will make them part of the record. Then, are there any inaccuracies, any modifications needed to the PSR?
No, Your Honor.
Any reason not to proceed to sentencing?
No, Your Honor.
Go ahead.
Thank you. Your Honor, Ms. Abbey, I would say, has made some of the biggest changes that I've ever witnessed in one of my clients through the time that I've represented her. She has completely thrown herself into her treatment programming. After she was released from jail, she immediately enrolled in Square One's residential treatment. She completed that residential treatment as well as their PHP and IOP programming. She is living currently in their sober living house, and she's doing that on a pay-for-stay basis. So she's actually completed the amount that they believe is important for her to complete in sober living as well. But she's remaining in that facility because it is keeping her accountable. They continue to drug test her, and she really appreciates the support and the staff that she's able to connect with there. Miss Abbey was struggling with methamphetamine use prior to her treatment, and it was really putting her in a very terrible place where she was associating with people not having a stable place to live, not being able to work, not being able to see her grandchildren. She was really, really in a bad place, and the person that I see here today is so much better, and I think that she's exactly the type of person that hopefully could overcome that presumption. She's shown the court that this is important to her, that she wants to remain a law-abiding citizen, that the relationship with her grandchildren is incredibly important to her. She's been volunteering at a local food bank. She has a sponsor, a co-sponsor, a home group. Really, I could go on and on about how productive she has been. And I just want the court to know that, that she is completely different, and it's shockingly different than when I would go and meet with her in the jail, and that I'm very proud. And so she also wants to thank the prosecutor and the court for everything that has happened, because it's truly changed her life, even just in this small amount of time. And so if the court would at this time, her sponsor would also like to say a few words, if that's okay. Her name is Rhonda.
Okay. Good morning.
Good morning, Your Honor.
And state your name, please.
I'm Rhonda.
Last name?
Rhonda Bishak, B as in Victor, I-S-H-A-K.
And R-H-O-N-D-A?
R-O-N-D-A.
And Ms. Vishak, you are Ms. Abbey's AA sponsor?
Yes.
And what do you want me to know?
I met Lori probably back in 2015 when she first came into the program. I knew then and there that she wasn't ready for it. She did walk out on that. And in this time, she's got nearly 7 months clean. and she asked me to be her sponsor again. And I asked her, are you done? Are you ready? Willing to do whatever I say or whatever it takes to become clean and sober? And she goes, yes. So I've been your sponsor for about 3 months now. And everything that I have suggested for her to do as a sponsor, she has done it. She's in the rooms. Just from the first time I met her to this time, what a difference. I mean, you know, she's found her higher power, who, you know, we do, is God. And we're getting ready to work the steps. So for me, Lori has turned around 180 degrees. I mean, she wants this. You know, she doesn't want to go back out in the streets like she was. And she's finding out that life is so much better on this side than when it was when she was drugged and drinking.
Thank you.
Thank you.
Your Honor, the only additional thing I forgot to mention is that Ms. Abby also did recently enroll in school to get her CDCA. She just started that program on Sunday. It's an online class that she's able to take, and so she's hoping that one day she'll be able to help support other people with substance use disorders, and that give them the support that she's had as well. On the date of her plea, we also did file an affidavit of indigency for Ms. Abby, knowing that there is a mandatory fine, so we would ask the court for consideration of that as well.
Okay. Lori Abby, do you have anything to say?
Your Honor, when this all happened, my mindset was very wrong. Am I being loud?
No, you're good.
My mindset was very wrong, and I felt a victim. I've already working on my program, and with the steps that I've taken thus far, I'm restarting my steps with my current sponsor, but the steps I've taken thus far have taught me I'm not a victim. I made myself a victim of me. What I did, the people I was around, the things I was doing, I'm glad this happened, because without this happening, I would not have done such a soul searching. I don't know as if everybody understands what working your steps is. And when you work them right, it's very surreal. You have to really look at yourself and the people around you. And the person I was surrounded by people who I had no business around. And it's not who I want to be, it's not what I want to do. I've been working really hard on my step work. I've been working really hard with my peers, and I do the volunteer work because by giving back, I also get back. And there was a time not too long ago I wouldn't have seen that. I wouldn't have even got what you were saying if you just said that to me. But I'm very sorry for having to be here, but I'm also very grateful, because without the events that took place, I would have never been brought to square one. I would have never started this journey that I'm on. It is a personal journey and a spiritual journey. And the reason I started taking my CDCA is because I want to get my chemical dependency license, because I do want to give back. I want to help people, because they're dying every day, and they don't need to. There is a way out, and I'm living proof of that. Thank you for your time.
Well, you're correct. My next hearing in 8 minutes, it's canceled because she died, overdosed. So, yeah, it's very true, and it happens a lot. Mr. Eggers?
Thank you, Your Honor. State of Ohio has reviewed the pre-sentence investigation. Would ask you to consider the defendant's remorse, acceptance of responsibility, and the work that she's done since she's entered plea into this case. The state of Ohio would believe that the presumption for prison has been overcome. We'd ask you to hand her a sentence of appropriate restrictions on community control sanctions. Thank you.
I've considered the record, the oral statements made, the pre-sentence report, drug and alcohol and psychological evaluations, my conference in chambers with counsel and probation, and the statements of the defendant and the defendant's counsel. I've also considered the overriding purposes of felony sentencing, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender and promote the effective rehabilitation of the offender using the minimum sanctions that the court determines accomplish those purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution, along with the public burden. I've considered the joint recommendation of the parties for a community-controlled sanction. I have reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders. In using my discretion to determine the most effective way to comply with the purposes and principles of sentencing, I've considered all relevant factors, including the seriousness and the recidivism factors set forth in the statute. In that regard, there are no factors making the offense more or less serious. In terms of recidivism, there are factors that make recidivism more likely. The defendant does have some history of criminal convictions and has not responded favorably to previously imposed sanctions. There are factors that make recidivism less likely. The defendant has no prior delinquency adjudications, is genuinely remorseful, and has taken steps to take control of her life and her future. There is a presumption for prison here, as there are no factors making the offense more or less serious. The factors making recidivism less likely outweigh factors making recidivism more likely, so the court will override the presumption in favor of prison, and especially pursuant to the agreement of the parties. The court further determines that prison is not needed to protect the public. The offender is amenable to an available community control sanction. If community control is appropriate, the court will adopt a joint recommendation and place the defendant on 2 years of community control, subject to the general supervision and control of the Lake County Adult Probation Department under such terms and conditions that it finds appropriate. Among these, you shall not leave the state of Ohio without the permission of the court, and you shall abide by all laws, including but not limited to the laws related to firearms, deadly weapons, and dangerous ordnance. The court further imposes the following specific sanctions and conditions: a period of incarceration in the Lake County Jail for 60 days with credit for 0 days served, with jail diversion on GPS to commence January 10th, 2023 at 9 o'clock a.m. So Kim, does that give enough time to set up the GPS? All right. You're to continue with your square one treatment program, complete the intensive outpatient treatment program and all aftercare recommendations. You're to be in the sober living facility for at least 6 months and follow all recommendations, including aftercare, complete abstinence from alcohol and drugs of abuse, periodic screens to monitor your compliance. You are to participate and attend 3 12-step program meetings per week at a minimum, have a sponsor, and be involved in a home group. You'd have full-time employment or school or combination of employment and school, but outside of any establishments that sell alcohol or drugs. I'm fining you $5,000 as the mandatory fine, but suspending it due to indigency as evidenced by the affidavit and the filing. You'd have 1 doctor, 1 dentist, 1 pharmacy at any one time prescribing or filling prescriptions for you. You're to inform the adult probation department of any change of provider and sign medical releases so that they can monitor any drug-seeking activity on your part. And you're to inform your providers of your addiction. You're to take all medicines as prescribed and forfeit all contraband and instrumentalities. You're to pay the costs of prosecution, confinement, community supervision, treatment, and court costs. Any violation will result in a prison term of 9, 12, 18, 24, 30, or 36 months in prison. If you do end up in prison, post-release control is optional for up to 2 years. They can return you to prison for up to 9 months for any one violation administratively, subject to being returned to prison for all violations together, up to 50% of the original prison term. I give you all of that time as part of the sentence. Should the violation of post-release control be a new felony, the judge in a new felony case, in addition to sending you to prison on a new case, can send you back to prison on this case for the greater of 1 year or whatever length of time remains unexpired, and that potential 2 years of PRC, and all of that time is part of the sentence. I explained to you the 8 or 10% credit. You have your GED, correct?
I have my high school diploma.
Your diploma. I explained to you when I took your plea about the 8% credit. If you end up in prison, you may be able to earn credit capped at 8% or a certain number of days for successfully completing programming. I also explained you may be able to substitute community service for the cost of prosecution if you're on community control rather than in prison, working at an offered rate of $10 per hour. Each hour of work performed reduces the judgment by that amount. Also, the state can block your motor vehicle registration so long as you owe any court costs until those costs are paid in full. Bond is released. Is there anything further from the state?
Nothing, Your Honor. Thank you.
Friends?
Nothing further, thank you.
Kim? All right. Sabby, you have taken
Jenny, do you want Craig to hang on?
You can take off if you want.
We all need you.
Craig's pretty cool.
He's a good man.
He is a good man. When I was ready, this girl Diane, she used to know them, like work with people, rated agency. Because I think he's like DEA and probation.
He is just a chief probation officer, you might know.
Oh, because I seen the hat in his office once and I was like, hey.
That might have been a gift.
Oh, all right. Because like 2018, I was working with people.
All rise. This court of common pleas is now in session. The Honorable Eugene A. Lucci presiding.
Have you seen it?
These are case numbers 18 CR 000-974, 18 CR 000-982, and 18 CR 000-983, all three cases, State of Ohio versus Beecher G. LaForce. Mr. LaForce is present in court, represented by counsel. Assistant Public Defender James Matthews, representing the State of Ohio, is Assistant Prosecuting Attorney Jenny Azuri. And on behalf of the Lake County Adult Probation Department is Probation Officer Kim Randallson. The defendant was sentenced in this court on February 11th, 2019 on the 974 case. Count 1, attempted grand theft motor vehicle felony 5. On the 982 case, count 1, breaking and entering felony 5. And count 2, grand theft motor vehicle felony 4. And on the 983 case, count 1, attempted grand theft motor vehicle felony 5, and count 2, receiving stolen property misdemeanor 1. I gave the defendant a sentence of 4 years, community control sanctions on all 3 cases, all counts concurrent. On the 982 case only, I imposed 196 days with credit for 151 days. The credit on the 983 case was 150 days. The credit on the 974 case was 148 days. He was to do the jail treatment program and aftercare only on the 982 case, followed by NeoCap, followed by transitional day reporting, complete abstinence from alcohol and drugs of abuse, periodic screens to monitor compliance. I established a curfew from 11 p.m. to 6 a.m., 1 doctor, 1 dentist, 1 pharmacy, full employment. I ordered restitution on the 982 case and on the 983 case to the victims. He was to continue his mental health at Beacon, following all recommendations, take all medicines as prescribed and other requirements. I told him a violation would result in a prison term of 12 months on each of the 3 F5s, 18 months on the F4, for a total consecutive of 54 months. I notified him of the potential and consequences for violation of post-release control. I explained the 8% credit, substituting community service for costs, and the state block on the motor vehicle registration. The defendant returned to the court on March 14th of 2022 on probation violation. He waived his probable cause in final hearings, pled guilty to using marijuana twice, a non-technical violation. I continued his community control for the original 4-year period, each count concurrent. I imposed 12 days in a Lake County jail on the 982 case, credit for 11 on the violation. I noted the overall credit on the 982 was 243 days, on the 983, 150 days, and on the 974, 148 days. He was to have a drug and alcohol evaluation and a mental health assessment at Crossroads and follow all recommendations. All other terms of the community control imposed on February 11th of 2019 remain in full force. I reiterated that a violation would result in the 54-month consecutive prison sentence, and I notified him of the potential and consequences of post-release control violation. The defendant returns to the court today on another set of probation violations. The violations were filed in each case. And the first violation was filed in an affidavit dated April 21st, 2022 by Officer Randallson. She alleged a violation of Rule 8, which requires sobriety. She says that defendant tested positive on March 25th, April 1st, and April 18th, 2022 for marijuana. She alleges a violation of Rule 1, which requires obedience to the law. She says that on April 16th, 2022, the defendant was arrested by Geauga County SO and charged with criminal trespass, M4, case number 22 CRB 00363, and breaking and entering, felony 5, case 22 CRA 00362. And just for the record, Kim, has that case been resolved, either of those?
The other county case has not been resolved. As of May of 22, there's still just a warrant for this.
Okay.
But the case in Virginia has been resolved.
Okay. So as to that one, when we get to it, the plea would be to getting arrested and not actually violating the law. Satisfactory with you?
Well, I guess
he's not entering any pleas. I guess this would be just the finding that you would have to make would be that he was arrested, had contact with law enforcement. Is that what you're referring to?
Well, he's not, this is the final hearing. He's not pleading to the violations?
No.
So what's he doing?
Well, it was the intention of Mr. LaForce, if this is still your intention, to have testimony taken to demonstrate these charges. Is that still your intention, Mr. LaForce? Do you want him to testify about violating by going to Virginia and testing positive for marijuana and getting arrested? Or do you not wish for her to testify?
I mean, honestly, I was just going with the court dates that were set. Last time we were here was the probable cause hearing. She stated facts, and then whatever you scheduled after that. I mean, I violated probation, but I'm saying the only thing I challenged was my time credit. That way I could see when my max was, so I can, you know what I mean? That way, in case I sat a little longer due to the fact that there was no court opening in time for me, the time credit was the only thing I challenged. So
You're talking about the time credit, not jail time credit, but time credit to the period of community control you were sentenced to?
No, I'm just saying, I had nothing challenging the fact that I had THC in my system. I mean, I reached out to her for help from Virginia. I wasn't hiding the fact that I had left the state. So the only thing I ever challenged from day one was the fact of what time do I have credited, so my max date, so I wasn't, getting like extended. I mean, I literally have done a lot of time since I've been pretty much locked up since 18.
So I noticed my note here that on November 28th, 2022, the court held a probable cause hearing after finding the defendant competent, and I found probable cause on all 4 charges on all 3 cases. The marijuana use on 3 occasions, arrested by Geauga SO, failing to report since April 29th of 2022, and travel to Virginia without permission of the court. So let me read the other 2 charges. An addendum filed August 10th, 2022, alleges a violation of Rule 3, which requires reporting as directed. The officer says that the defendant failed to report on April 29th, 2022, and thereafter. And then another addendum, the second addendum, dated August 12th, 2022, alleges a violation of Rule 9, which says you shall not leave Lake County without the permission of the probation officer, cannot leave the state of Ohio without permission of the court. She says that the defendant is currently in the Duffield Regional Jail in Virginia. The defendant was never granted permission to travel to Virginia. So those are the charges the court found took evidence on November 28th, 2022 on that. And both sides stipulate that the evidence I took on that day is the same evidence I would take today to substantiate the charges. I mean, the officer testified he was in Virginia without permission. She can testify again today that he was in Virginia without permission, but it's the exact same testimony as it was a month and a week ago. Right?
I will say that I am not aware of any evidence that would be presented that was not presented, but I don't.
I don't believe there would be any.
I mean, is there any more cross-examination that you would do?
I don't believe I did any the first time.
Yeah, I know. Is there any more?
I did not have any questions prepared.
Okay.
If there were an issue that would arise, I would, of course,
all right.
inquire.
So the charges are that he failed to report April 29th, 2022. The officer testified at the probable cause hearing. That's the truth of it. Is there any dispute on that?
Mr. LaForce, do you dispute that you were in the state of Virginia without permission, or?
No, I actually had contacted the courts and probation and told them where I was and what was going on. I had actually tried to remove counsel from the public defender's office since I've been arrested since October also, because due to the facts that you guys keep extending this, making it look like we're challenging things that we're not challenging things. I mean, I presented the courts and probation with the facts and admitted to what I'd done and had been begging for your office to resign from my case so I could just let the courts.
Is there any dispute that there were 3 positive urine screens for marijuana?
No, sir.
No dispute that you got arrested by Geauga SO?
No, sir.
No dispute you were in Virginia without permission?
No, sir.
And that you failed to report on April 29, 2022 and thereafter?
That is correct.
Okay. You understand your exposure is the maximum of 12 months on each of the 3 F5s and 18 months on the F4 for a total of 54 months in prison. You understand that's your exposure?
Yes, sir.
Of course, getting credit for time served calculated appropriately. You understand that?
Correct.
And have you discussed with your attorney the waiver of a full hearing on this, on the merits of it, not the sentencing, the full hearing on the merits of whether you violated the order in the way that the probation officer alleged, and admitting to the violations?
No, Your Honor, I've not disclosed any of that with my attorney. I've tried to reach out to that office and...
Okay. So you understand you could require the state of Ohio to present the evidence that we talked about. Correct. You understand that? And you understand if you gave up that right, requiring the state to present the evidence, then the state wouldn't present the evidence. You understand that?
Correct.
And you understand your maximum exposure here, correct? Of
Yes.
54 months in prison minus time served, properly calculated. You understand that?
Yes, sir.
And do you give up the right to a final hearing?
Yes, sir.
Do you give up the right, and do you wish to plead guilty to the 4 violations?
That is correct.
Court finds that the defendant has knowingly, voluntarily, and intelligently waived his right to a final hearing on each of the 4 violations, has entered a plea of guilty on the 4 violations. Court finds the defendant guilty on the 4 violations and determines that all of them are non-technical violations because they evidence a state of mind of abandonment of the purposes for community control. Any reason not to proceed to sentencing at this time, Mr. Matthews?
No, Your Honor.
You may address the court first.
Thank you. Your Honor, as Mr. LaForce has stated, he has served a significant amount of time between jail, NeoCap, and that doesn't include time over the past few years that he has been in other institutions. He does believe that for the offenses that he was found guilty to of in this court, that he has served a sufficient amount of time. He would ask the court consider crediting him, Your Honor, for the time that he has served up to this point. Thank you.
And Ms. Beecher, LaForce, do you have anything to say before I sentence you?
I just ask the honor that you take into consideration, like my attorney said, pretty much the amount of time I've done, and help me move past this point, so I can return back to the things I lost and back to work. Other than that, that's all I have, sir.
All right, let me hear from the state.
Thank you, Your Honor. Your Honor, we're dealing with 4 separate probation violations stemming from March of 2022, which also included leaving the state of Ohio without permission. The defendant has exhibited that he is no longer amenable to community control, so the state would recommend a prison sentence on these cases with credit retention.
State is something that essentially violates your probation, but they not the probation terminated, and they believe prison sentence punishment for credit for I impose.
Chance, I got a month.
Well, no. The amount of time that remains what you can be sentenced to and the charges that you are guilty of is a separate matter from when a period of probation will expire. Those are 2 separate matters.
Yeah, it's like triple jeopardy on 1 sentence. If you sentence me to 4 years probation, that's my sentence on an agreed document. But if Ms. Tuttle would have proved that I had the keys to the car, I never had grand theft authority. I had the deed to the house. I never broke into a home. I just keep getting. I'm a good man. I came out of prison, had a brand new truck and job as soon as I got out. I mean, I've contacted your office since I've been here asking you guys to help me build a defense.
Well, that's kind of the issue that we've had with this case.
What's the good that you know that I've done since I've been home? Did you tell him I got a truck as soon as I got out? A 27?
Kim, has the restitution been paid?
It was not.
I paid everything at the municipal court. The only restitution I knew about, I paid $1,004.10 straight out of prison. So I mean, I don't.
Any restitution on this case would go through the adult probation.
And I was not aware that no one broke these things down. I would have paid that. I want you guys to see the good I've done. And I just did 3 years, almost 4 years in confinement, and my mom almost died, my dad just died. Like, you've done nothing for me, man. Where's my defense? Talk about the good. You're supposed to represent me against the state, not know what the state says. Did you get my employment history? Did you get anything for me?
Hold on. Just so the record is clear, the defendant is having a conversation with his attorney. I'm not recognizing this as being on the record because you're not addressing me.
No, sir, I apologize.
Okay. I just want to make sure that all this, the mumbling has been between counsel and his client, and it's not been with the court.
That is correct.
Well, would you like to express these things to the court?
No.
So that they would be on the record?
I don't have an issue with the courts. My issue is the defense that nobody had built for me to protect my rights, protect me. What do you get paid to? You get paid to represent me. Show the good. Show the good for me. So I'm not judged from my past. I'm tired of being in jail. I'm tired of not being home with my kid.
Perhaps As soon as you finish, you should tell the judge something.
Then resign from my case like I asked you to do 5 months ago. And I would have presented them to the judge myself. I would have came here with a file of stuff and presented all the good. You've done nothing but represent a sentencing order and say, I would like time for the time credit. No, you know what I would like in your leave? I would like to go home today.
That's what
I would like you asked that I had time for credit.
I asked for the sentence to be credit for the time you have served.
And you should have said for time served and release. The defendant wishes to be released today if the court's taking into consideration.
Just so the record is clear, Your Honor, so Mr. LaForce, if my position needed to be clarified, my request for credit for time served was a request that the extent of the sentence be limited to the time that Mr. LaForce, has already served. That being...
Well, that's what I understood.
Okay, I just wanted to make sure that everyone understood that that is what I was asking for, which was that you would go home. Okay?
That's what I understood.
Thank you.
But I don't want to stir a hornet's nest here, but as I overheard, and could not help but overhearing, you had complaints about Mr. Matthews' handling of your case, and although you pled guilty, are you saying that you're not guilty?
No, I mean, Your Honor, I'm guilty of the violation.
No. Were you talking about the original crimes, or are you talking about the probation violations?
No, I had went back with him and addressed from the beginning because I had...
Well, that's my concern, that you're going back that far and addressing things that happened 3 years ago.
Well, Your Honor, I was only addressing that because since that office, since the day I got over there, I said I had written letters about Ms. Tuttle, I've written letters about Ms. Clapp. They refused to remove themselves from representing my case. And that's why I brought that up, because I said since day one, I never filled out a public defender's application or nothing. And I felt that the whole time I've talked to this gentleman 3 times, and he's not built any defense for me the whole time. I've sent everything out. I sent the court's letters, I sent the prosecutor letters, I sent probation letters. I've been by myself, reaching out, getting every paperwork I could get sent in. I mean, as a defense attorney, it bothers me that I've not been properly represented by that office, as in here, Your Honor, here's the facts that my client did. He had a job within a week of being out of jail. He just did 4 years, 3 years in prison. He had a job. A month later, he had a 2017 truck on a payment plan. Outside of that, he had his own place. He had his kid back in his life.
But you understand, those are not defenses to the charges.
Yeah, I understand that.
See, when I hear that, when I hear you say that you were not properly defended here, the question becomes, do you have a defense to the charges, a legal defense to the charges? Like you didn't do them, or you're not criminally liable for the charges. That's the first thing that comes to my attention. Now, you've already served 3 years of community control on this, or 2+ years of community control on this. And I want to make sure you're not asking that everything be set aside and you start from scratch with a trial. Because that would be what would happen if you withdrew your plea on the cases. You would go to trial on all the original charges. Is that what you're saying that you want to do, or are you just confusing yourself and confusing me?
No, Your Honor, I mean, that opened up, that's something I've challenged from day one, because, I mean, I was charged for breaking and entering into a house that I had the petition document, the living deed from Wayne Hawley to be at that property, and the public defenders didn't. And then the cars, like, they charged me with grand theft auto. It should have been unauthorized use of a motor vehicle. I had the keys. I drove them. I got in trouble. I didn't have no criminal intentions. I was doing what this woman, Jeanette Escu, had told me to do. And I went looking for a job. And so I mean,
why am I hearing about this for the first time? Or did I already have a hearing on this and they just don't have my notes in front of me?
No, Your Honor, you did not. I was put on psych meds in 2018, and I was a zombie all the way until 2019. Whenever I got to NeoCat, I seen Coleman Medical Services, and the man said, you don't remember nothing. I said, I had to go back and ask my teachers. I said, what did I learn the last few months that I've been here? I said, the meds have made me a zombie. So that is proper reason why I did not challenge nothing on my own in 2018 and 2019.
But when I had you here for a competency hearing in November and found you were competent, you didn't raise it then either.
I was not aware, Your Honor, that I could raise it. I just...
Well, whether you were aware that you would raise it or not, if you felt that you were being railroaded, so to speak, by your attorney, it would be natural for you to say, hey, I'd like to bring this to your attention. But, I mean, that was on the first probation violation. I mean, the second set of probation violations. Because you've already been here for sentencing and one probation violation back in March of 2022. Correct. So why am I just hearing your extreme dissatisfaction with your attorney's performance now for the first time, and the case has been going on for 3 years?
Your Honor, I've returned. Since I returned here, I complained.
When you say when you were returned here, when are you talking about?
When I got released from prison,
from
January.
Virginia?
No, Pennsylvania. January 7th, 2022. I went to the courthouse, started addressing things. I came back and I asked Miss Tuttle, hey, this is not right. And she said, oh, they're just going to give you 12 days. It's better than sending you to prison, ain't it? I said, yeah, you know. And I kept telling her this wasn't right. And then this time back, I'm just like, well, I got to stand up for something. I do wrong. I get held accountable for my actions. I own up to my consequences. You know what I mean? I get consequences for my actions. But I've not done all this wrong. I would gladly like to go to trial if that was a possibility. But it's just, I sit here with no money in the jail. I can't sit. Now if I had like house arrest bracelet or a bond, so I could go to trial and prove that I've been innocent on a lot of this, I would gladly take that opportunity.
You don't have to prove your innocence. The state would have to prove your guilt. But you admitted to me that you were guilty.
And I did.
I wouldn't have sentenced you if you hadn't admitted to me that you were guilty of all of the crimes for which I sentenced you.
That's correct, Your Honor. Because Ms. Tuttle told me, she said, if you take these psych meds, you'll go home when you go to court. I ain't never been home for a couple months.
When are you talking about having this conversation with Ms. Tuttle?
Miss Tackett came over to the jail.
Who's Miss Tackett?
a public defender from over there.
Are we talking years ago? She's
Yes.
no longer with them. She hasn't been with them for years.
Okay, then it would have been, yeah, this was when I was first arrested on these charges. I've been asking that office to remove themselves so I can file my own paperwork. And I talked to Ms. Clapp, and she says she has letters over there complaining, but she failed to address it. Like, I filed motions on my own this time currently in Lake County Jail, asking to remove counsel, asking for my sentence to be reviewed. None of them went through, but I filed the motions for the man in the next unit, and his went through in a week. I said, how does his get accepted? I wrote him up the same way. So it's not in my writing, I did my legal work correct. It's just somebody has a blocker there and they don't. It's like I'm not being able to speak up for my own since day one. But I did.
You understand that you have some mental illness, right?
Yeah. Yes.
You do understand that. And that complicates things.
Correct.
And it complicates things because a lot of time was devoted to determining whether you are legally competent to stand trial or to face the probation violation charges. You understand that?
Correct.
And just because you're mentally ill, you can still be competent, and if you are competent, regardless of the mental illness, I would still have to handle your case. Certainly I would take that into consideration, that you're mentally ill, as I would take everything else into consideration. But I've had enough interaction with you, you really can't represent yourself. You can't represent yourself properly. I have that much experience with you, I can tell you, that you have to rely upon attorneys. And all the attorneys that you mentioned are competent attorneys. So my concern is you're talking about trying to prove yourself innocent of the original charges. It's not your duty to prove yourself innocent of anything. And why are we going back to the original charges when you've been before me? Now, this is the third time you've been in front of me, and you include the probable cause hearing and the competency and the previous probation violation, and I'm just hearing about this for the first time. So you had rights that were at stake that should have been raised, and you didn't raise them, and you say you want to represent yourself. The fact that you didn't raise them is further proof that you really can't represent yourself, because if they're true, they should have been raised. Now, you've already got 456 days under your belt on this. If I couldn't possibly reset this back to zero. You've got 456 days in on this. I was going to give you a few more months in prison and you'd be done with it. But if you're telling me that you want to do something else, then I need to know what is it that you want to do and how would you have me do it?
Your Honor, I really don't know. I mean, I feel if I had a court-appointed attorney.
Well, you do.
And because I've asked Ms. Tuttle even in March, whenever I came back in front of the courts, I said, Ms. Tuttle, what about my original sentence? She said, it's too late for that. You pled guilty. But whoever Jeanette Esco was like, oh, I'm going to use you, we're going to work. Told me I could use this truck, and I ended up in jail for 4 years. So I went through a bunch of turmoil and
what do you mean you ended up in jail for 4 years?
Well, I got sentenced to probation for 4 years, and then that violated.
Okay, that's different than jail for 4 years.
Correct.
You have 456 days time in between all three cases.
Correct.
It's not 4 years. It's not quite 100 days past 1 year.
See, I was aware that my time, I had spoke with probation, they said it counted the whole time I was in Pennsylvania, the whole time through NeoCap, probation counted. So I had no...
Well, we wouldn't count the 2 years and 4 months that you left. Weren't you gone for 2 years and 2 months, something like that?
Yeah, like 2 years and 5 months in Pennsylvania.
And you were in Pennsylvania. You don't get credit for the time you did in Pennsylvania for the crime you did here. You've offended against the Commonwealth of Pennsylvania, and they punished you for that. They're not punishing you for offending against the state of Ohio.
Correct, Your Honor. That's why I've been so confused.
And for the period of community control, the probationary period, we don't count the time that you were out of state because you weren't reporting to us, you weren't subject to, I couldn't get a hold of you if I wanted to get a hold of you. So the period of time that you've left the state of Ohio, whether to Pennsylvania or Virginia, because you were both in Pennsylvania and Virginia, none of that time counts because you absconded from the state. You understand that?
Yes, Your Honor.
So what's presented to me here is you've committed a series of serious violations. The drug use is the minimal of it. You left the state of Ohio. You absconded. You were arrested for committing other crimes. And when were the crimes committed in Pennsylvania? Before these crimes?
In 2009.
Okay.
And that
Pennsylvania finally got up to you, and they had you at F2 burglary.
No, Your Honor. Oops, sorry. No, Your Honor. I was sentenced in 2009. I was on parole here, supervised through APA.
Okay.
And then violated, went back after I did my time here, because it said I first had to serve my sentence in the state of Ohio before returning to the state of Pennsylvania, is what my court paper said. So when I left here and I went to Pennsylvania to finish my term, I was aware, I thought everything was credited. And when I got out, I was like, oh, I'm off probation. And I kept challenging it from day one. I said, well, one person's crediting this time, one person's telling me this time doesn't credit. So honestly, I was just kind of getting bounced around. So I was only trying to find the truth. And then when I went to Virginia, I went without leaving, you're correct, and I went down there to a home that my family owned, and I did not waive extradition at first. I sat 90 days. After 90 days, if they don't have a governor's warrant, they're supposed to lift their warrant on me until they secure a governor's warrant. Nobody from adult probation or the state of Ohio had came with a governor's warrant. So I went in front of the judge, and the judge said, what else do we do? I said, well, if they're not going to release the hold after 90 days, as the law requires, they must have a governor's warrant, and if they don't after 90 days, I get released. I said, if they're not going to release it, I waited an extra 10 days, and then I waived my right of extradition.
And you did all this representing yourself?
No, that Stephanie Chadwell was my representation, but...
I don't know who she...
Oh, it was through the Lee County courts, but that's what I stated to the judge on my own.
Virginia or Pennsylvania?
Virginia, Jonesville, Virginia, Lee County. But Your Honor, I did not waive my right of extradition, and I was still picked up by the state after 90 days without a governor's warrant. And that was my first thing that I challenged when I got back here. Not the fact that I was in the wrong, the fact that the state failed to properly get the documents.
Do we routinely have probationers waive extradition?
Do we traditionally have?
No. Did we have a waiver of extradition? How did Craig pick him up if there was no waiver? Did they have a hearing there?
Right. He did have a hearing there.
Oh, okay. All right, so you had a hearing on the extradition in Virginia.
Correct, and I didn't waive my rights my extradition until 9/27 or 26. After being forced, I was picked up June 18th. I waited 90 days, and I was forced to waive it because Ohio refused.
Okay. You understand, I don't know any of this.
Oh, okay.
What am I supposed to do with this? Let me have the state talk for a second. What am I supposed to do? All this stuff is being presented to me on something that was a 28-minute hearing.
As to what specifically, Your Honor?
Procedurally, what's the state's position where we are?
Well, procedurally, he pled by information in all counts back in December of 18. He was sentenced in 19. He's been before the court for a prior violation. He had a hearing in this case. He waived today. He pled guilty. So as far as the state sees, he's here to be sentenced on these probation violations. We have credit. I think you said 450 some credit.
456.
Yeah. In the 982 case. I think we have where he has pled guilty to the violations. If there's more information that he wants to present to the court for mitigation, perhaps we do that at another time. But I think the record is clear that we have the plea and finding.
Well, here's the problem. I don't have another time because I'm leaving this bench. Just so the record's clear, I've been elected to the Court of Appeals. So when am I going to be able to hear this before I move on? Or do I have to leave all of this to my successor who's going to say, how could this judge leave me such a mess? And I'm just hearing about this mess for the first time right now. I can't leave this to my successor to sort out because I'm having a hard time sorting this out. And my successor has no judicial experience whatsoever because I know all the applicants. So what am I supposed to do? Mr. Matthews, what do you think?
Go ahead and go ahead and speak up.
Well, what would you like to say?
I just want things done properly. You know what I mean?
All right. Your Honor, my office is not in the habit of advising clients to plead guilty by way of information without a very firm belief in the mind of the attorney that the plea is of benefit to the client, that the benefits of pleading by way of information would outweigh the chances of success at trial. I was not the attorney who handled Mr. LaForce's changes of plea in 19, but certainly we all know Ms. Tuttle to be an attorney who would never advise her clients to do something that she did not believe was the right thing. I am not aware of the evidence that would have been presented at trial in any of those cases. I am certain that Ms. Tuttle was aware of that evidence, and being aware of that evidence, made the recommendation to Mr. LaForce that he plead by way of information on all three of those charges. When we advise our clients to plead, we are also not in the habit of going back and recommending that they withdraw those pleas, particularly, as you stated, after they have served over 400 days between jail and NeoCap, and are now in a position where they have pled guilty to 4 violations of probation, and we are set for sentencing on those violations. We do not, at this stage of the proceedings, certainly not routinely, but I cannot even recall an instance in my 22 years of an attorney from my office saying that at this stage of the proceedings that one should go back and undo everything and request that pleas be withdrawn. I am particularly aware of this court's thoroughness in the acceptance of a plea of guilt, and my experience tells me that were there to have been any legitimate doubts in Mr. LaForce's mind, that this court would have fleshed them out and not taken his plea were the court not confident that Mr. LaForce was doing so knowingly and voluntarily. So with that being what I know to be the common practice both of our office and of this court, I am not in a position today to recommend to Mr. LaForce that he request to withdraw any pleas that he made on these underlying charges. I would say at this point, if the court is comfortable going forward in sentencing Mr. LaForce, that the court consider not only the time that he has served, but the fact that Mr. LaForce is very obviously dealing with issues that do not manifest themselves in the vast majority of the people that come before this court. I have had a tremendous number of conversations with Mr. LaForce regarding a variety of issues, not only with this probation violation, the facts of it, but procedurally, the discussion of jail time credit, the length of the period of community control, why that period of community control is still in effect. I cannot say that I believe Mr. LaForce agrees with our positions that my office has taken regarding those issues, but I do believe that those positions are grounded in a firm understanding of the law of tolling of time on community control, as well as the fact that when a jail sentence is imposed and credit is imposed, that credit is not applicable to the period of community control at sentencing. So having, to the best of my ability, certainly, and I believe of Ms. Clapp's ability also, we have done everything that we can to convey these facts, I'm just going to call them, to Mr. LaForce. And again, I cannot say that he has fully accepted them, but I do believe that they are true. All I think he's asking for today, Your Honor, is that you consider everything surrounding both the amount of time he's been incarcerated, the unique challenges that he faces, and that you would fashion a sentence that would be fair in this case, Your Honor. And what Mr. LaForce is again requesting is that he be credited the time that he has served, be released from probation, and be permitted to move on to Geauga County, where he will be dealing with his other legal issues that he has there. Thank you.
All right. I've considered the record, oral statements made, pre-sentence report, my conference in chambers with counsel and probation, statements of the defendant and the defendant's counsel. I've considered the overriding purposes of felony sentencing pursuant to Revised Code 2929.11, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender and promote the effective rehabilitation of the offender using the minimum sanctions that the court determines accomplish those purposes without imposing an unnecessary burden on state or local government resources. I've considered the need for incapacitation, deterrence, rehabilitation, and restitution along with the public burden. On governmental resources, I've considered the various recommendations of the parties. I have reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society and the victims, and to be consistent with sentences imposed for similar crimes committed by similar offenders. In using my discretion, I've considered all relevant factors, including the seriousness and the recidivism factors set forth in Divisions B through E of Revised Code 2929.12. In regard to the probation violations, the court finds that the defendant has knowingly, voluntarily, and intelligently waived his right to a final hearing and entered a plea of guilty to the 4 violations. The court finds the defendant guilty of all 4 violations, just so that the record is clear. Any oral motion, however expressed, to vacate the plea, motion to proceed pro se, motion to adjust the community control period, computation, the motion for ineffective assistance of counsel, all of those are denied. Your community control sanction is terminated. I'm imposing prison on the 974 case, count 1, felony 5, 6 months with no credit. On a 982 case, count 1, felony 5, 6 months, concurrent with count 2, 12 months. With credit for 454 days. And in the 983 case, count 1, the F5, 6 months with credit for 2 days. All consecutive for a total of 24 months with credit for 456 days. The restitution remains unpaid in full, so it should be reiterated that it remains due in full. Judgment for that amount to be monitored by the Ohio Adult Parole Authority, payable through the Clerk of Courts. You pay the costs of confinement, prosecution, supervision, treatment, and court costs. On your release from prison, you could be on post-release control for a period of up to 2 years, subject to the general supervision and control of the Ohio Adult Parole Authority. They can return you administratively for up to 9 months for any one violation and up to 1 year for all violations in the aggregate. All of that time is part of the sentence. Should the violation of post-release control be a new felony, the judge in the new felony case, in addition to sending you to prison on the new case, and send you back to prison on this case for the greater of 1 year, or whatever length of time remains unexpired on that potential 2 years. All of that time is part of the sentence. While in prison, you may be eligible for, be offered, and be able to earn some credit, capped at 8% of time to be served, for a certain number of days according to the regulations for engaging in programming offered to you for that purpose. So long as you owe any court costs, the state can block your motor vehicle registration until those are paid in full. And just so the record is clear as to the seriousness and recidivism factors that I mentioned that I considered, nothing's changed with regard to seriousness from the original sentencing date, but with regard to recidivism, recidivism is more likely because of the various violations. This time, the previous violation, there is a previous criminal history and a rehabilitation failure, and a failure to respond to community control. In terms of making recidivism less likely, I understand the defendant is trying and thinks that he did things according to the rules, and that might be because of his mental illness, but he did not, and has to be held accountable accordingly. And by the way, his mental illness is a recidivism likely factor also. and the court determined that prison is needed to protect the public from future crime. He's not amenable to an available community control sentence. Consecutive sentences are necessary to protect the public and punish the offender, are not disproportionate to his conduct and the danger he poses, and the harm is so great or unusual that a single term would not adequately reflect the seriousness of the conduct. The court does note that on the F5s, the court gave the defendant the minimum prison term, just so that record is clear. Is there anything further from the state?
Your Honor, in the 982 case, I just want to confirm that count 1, 6 months concurrent to count 2 of 12 months.
Right.
With 454 days of credit.
Right.
Okay.
Isn't that's what I said, right?
Okay. But 454 exceeds.
Oh. A mistake. That's why you shouldn't do math in public.
Just over 15 months, Your Honor.
On a 92, it has to be 16 months on count 2. And the total would be $983 is concurrent. So, in the 974, 6 months is consecutive with the 982. Count 1, 6 months is concurrent with count 2, 16 months. Credit's 454, and it's concurrent with the 983 case. Count 1 for 6 months. So the total would be 22 months with credit for 456 days. Thanks for catching that. Matthews?
Nothing further, Your Honor. Thank you.
Kim, anything?
No, Your Honor.
So if you've been doing the math, roughly 7 more
Yes.
months. All right, good luck. We're
January 1st. All rise. The Board of Common Pleas is now in session. The Honorable Eugene A. Lucci presides.
This is case number 21 CR 000738, State of Ohio versus Gregory A. Altizer. Mr. Altizer is in court, represented by counsel, Assistant Public Defender Conchetta Regazione. On behalf of the Lake County Adult Probation Department is Probation Officer Megan Behagen. Defendant was here on September 7th, 2021. He waived indictment, pled guilty as charged. Count 1, aggravated assault. Felony 4. I referred him for a pre-sentence investigation and reports at sentencing and continued his bond. I sentenced the defendant on November 10th, 2021, adopting a joint recommendation, placed the defendant on community control for 2 years. Imposed 63 days in jail, credit for 3 days. The remaining 60 days was deferred pending completion of an intensive outpatient treatment program and anger management program before March 15th of 2022. He was to do an IOP at Signature Health, follow all recommendations including aftercare, abstinence, screens, 4 12-step program meetings per week, have a sponsor, be involved in a home group, GPS until further order, paid by the grant under jail diversion, full-time employment or school, mental health assessment, and follow all recommendations, 1 doctor, 1 dentist, 1 pharmacy, take all medicines as prescribed, forfeit all the items in specification, no contact order. He was to continue and complete anger management counseling program at Signature Health and other requirements. I told him a violation would result in a prison term of 6 to 18 months. I notified him of the potential and consequences for violation of post-release control. I explained the 8% credit, substituting community service for costs, and the state block on the motor vehicle registration. The defendant is before the court on a probation violation. The probation violation is documented in an affidavit dated September 6, 2022 by Officer Wehagen. She alleges a violation of Rule 8, which requires sobriety. She says that the defendant tested positive for alcohol at Signature Health on March 18th, March 25th, June 9th, June 20th, and July 11th of 2022. I met with defense counsel and probation officer in chambers, and one, I learned that all those positives were in aftercare from the IOP, and I also learned that from your attorney that you wish to give up your right to a probable cause hearing and to a final hearing and plead guilty to the charge. Is that your understanding as to what you want to do here today?
Yes, Your Honor.
You understand you have a right to have a probable cause hearing, the purpose of which is for the court to determine whether there's a reason to continue to hold you to answer for the violation. You're entitled to a final hearing whereby the court would require evidence to its satisfaction that you violated in the way alleged in the officer's affidavit, and if I so find, you're entitled to a sentencing hearing. Do you understand these hearing rights?
Yes, Your Honor.
You understand your exposure is that 14 months in prison I told you about.
Yes.
Correction, 18 months in prison I told you about.
Yes, Your Honor.
Have you discussed with your attorney the waiver of your hearing rights, probable cause and final, a plea of guilty to the violation, and any other options you may have at this point?
Yes, Your Honor.
And has she answered all of your questions to your satisfaction about that?
Yes, Your Honor.
Do you give up the right to a probable cause hearing?
Yes.
Do you give up the right to a final hearing?
Yes.
What is your plea to the violation? Positive for alcohol on 5 occasions while in aftercare.
Guilty.
Court finds that the defendant has knowingly, voluntarily, and intelligently waived his rights to a probable cause and to a final hearing, has entered a plea of guilty to the violation. Court finds that the violation has demonstrated a refusal to participate in the community control sanction imposed or has abandoned its objects, and therefore determined that it is a technical violation. Any reason not to proceed?
No, Your Honor.
Go ahead.
Thank you, Your Honor. Your Honor, my client explained to me that back at the time of these violations, he had obviously relapsed on alcohol. He was going through a very difficult time and struggling with depression, and he recognizes he should have reached out and utilized his tools rather than fall back on the drinking. He has learned a lot since then. He did get back into the IOP at Signature Health, so even though he had completed it and was in aftercare, he did re-up and get into that intensive outpatient therapy again. He is just about completed with that. He did provide documentation showing that he is just about completing that on January 5th, and he will then be back in aftercare at Signature Health. He is currently still on the GPS monitoring through the jail diversion program. He is currently working. His boss is here in the courtroom for support, and he did express to me that Mr. Altuzer is a very good employee. He's one of the few that he can actually count on to come to work and do his job. He is very happy with him. He's doing construction work, and he is doing that full time. So I would ask the court to continue Mr. Altuzer on probation, to allow him to complete the IOP, to get back into the aftercare and continue working. Thank you.
Gregory Altizer, the law allows you to say whatever it is you want me to consider before I sentence you. Do you have anything to say?
You know, there really ain't no excuse. You know, I messed up. I shouldn't have, you know, I do have a sponsor. I have sober support. I have a home group next door at the church there on Tuesday nights, which hopefully I can go tonight. I just, you know, I actually got a primary doctor. I am trying to do better for myself. You know, I just, yeah, we respect whatever decision you make.
Okay, you understand, alcohol is it's your downfall. It's bad for you.
I feel good. These last 3 months, it's been over 3 months since I've had a drink, and I do
if you're
feel
not
good.
drinking, you feel good.
Then my head isn't all clouded, you know, like I think more clearly than ever.
I consider the record, oral statements made, pre-sentence report, a conference in chambers with counsel, defense counsel, probation officer, and statements of the defendant and the defendant's counsel. I've also considered the overriding purposes of felony sentencing, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender and promote the effective rehabilitation of the offender using the minimum sanctions that the court determines accomplish those purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution, along with the public burden. I've considered the recommendations of the parties. I have reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing and be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society and the victim, and to be consistent with sentences imposed for similar crimes committed by similar offenders, and using my discretion to determine the most effective way to comply with the purposes and principles of sentencing. I have considered all relevant factors, including the seriousness and the recidivism factors set forth in the statute. Been no change in seriousness factors in terms of recidivism. In addition to what's been previously, there has been a rehabilitation failure and a failure to respond to community control. There's a pattern of alcohol abuse, and the offender refuses to acknowledge a problem or accept treatment or apply treatment tools previously given to him. Nonetheless, the court believes that the defendant remains amenable to an available community control sanction. Continuing your community control for the original 2-year period, you're to finish the aftercare on your second IOP treatment without any violations. The GPS device can be removed. All of the conditions remain as previously ordered on November 10th, 2021. A violation will result in a prison term of 6 to 18 months. You're reminded that if you do end up in prison, post-release control is optional for up to 2 years. They can return you administratively for up to 9 months, even for one violation. All of that time is part of the sentence. Should the violation be a new felony, the judge in the new felony case, in addition to sending you to prison on the new case, can send you back to prison on this case for the greater of 1 year or whatever length of time remains unexpired, and that potential 2 years of PRC and all of that time is part of the sentence. Anything further from the defense?
No, Your Honor, thank you.
Probation? All right, good luck. For the record, this is case number 22 CR 000864, State of Ohio versus Deshaun N. Jenkins. Is that your name?
Yes.
Mr. Jenkins is in court, represented by counsel. Attorney Edward LaRue, representing the State of Ohio, is Assistant Prosecuting Attorney Rocco DiPiero. Mr. Jenkins, you are charged in a 2-count information filed by the Lake County Prosecuting Attorney on October 12th, 2022. Count 1 is possession of cocaine, felony 1 with mandatory prison. Count 2 is having weapons while under disability, felony 3. The felony 1 is a Senate Bill 201 qualifying offense, meaning qualifying for an indefinite prison term of 50% of the prison term I give you on that particular count. So count 1 carries a minimum prison term of 3 to 11 years, a whole number of years between 3 and 11, and a maximum term of 50% over that. So just as an example, if I gave you 3 years, then half of 3 is 1.5. Add that to the 3, 4.5 years. So the lowest minimum is 3, the lowest maximum is 4.5. If I gave you 11 years, half of that is 5.5. So the longest maximum would be 16.5. And then on count 2, the weapons under disability, felony 3 carries a maximum penalty of 36 months in prison. Minimum prison on felony 3 is 9 months, and it's 9, 12, 18, 24, 30, or 36 months. There's a mandatory fine on count 1, minimum $10,000, maximum $20,000. And those are the most serious penalties. So you understand the range of penalties here?
Yes.
You understand you have the right to have the Lake County Grand Jury consider the evidence as presented by the prosecuting attorney and for the grand jury to determine the charge or charges. In doing so, they could land on the same 2 charges we have here. They could charge you with something more, something less, or nothing at all. The point is, it's totally up to the grand jury. Do you understand that?
No.
And have you discussed this decision with your attorney about waiving indictment and pleading guilty to a prosecutor's information?
Yes.
And has he answered all of your questions to your satisfaction about that topic?
Yes.
So do you give up the right of indictment?
Yes.
I'm going to hand you a document called Waiver of Indictment. Make sure you've read it. Make sure you understand what it says. Make sure you agree with what it says. And if you sign it only because that's what you want to do. Counsel, if you'd approach to retrieve the document.
Your Honor, the defendant, Mr. LaRue, and I have signed the waiver of indictment form. With the court's permission, I'll approach to present that one to Your Honor.
Yes. I will make the waiver of indictment part of the record in the case. So you've been charged with possession of cocaine, felony 1, having weapons while under disability, felony 3. Before I can accept your plea of guilty to these 2 charges, I have to determine if you know and understand the rights you are giving up, the consequences of a guilty plea, and that you are entering the pleas of guilty of your own free will. How old are you?
32.
And how far did you go in school?
10th grade.
And do you have the ability to read, write, and understand the English language?
Yes.
You hold any kind of state-issued occupational license or certification?
No.
Are you a U.S. citizen?
Yes.
Are you currently under the influence of any drugs, alcohol, or medication of any kind?
No.
Have you taken any within the last 48 hours?
No.
Have you ever been medicated, hospitalized, or treated for any mental illness in your life?
No.
Have you received a copy of the information, prosecutor's information?
Have I received a copy?
Yes.
No, I haven't.
You've never received a copy? You never held it in your hand?
I read it. I ain't got a copy of my own.
Pardon?
I said, I don't have a copy of my own, no.
Okay. But you've seen it?
Yes.
You've read it?
Yes.
It was given to you?
Yes.
You understand the charges?
Yep.
Did you discuss the charges with your attorney?
Yes.
Did he answer all of your questions to your satisfaction about those charges?
Yes.
Do you agree that those 2 charges describe what you did here?
Yes.
And you wish to plead guilty to those 2 charges?
Yes.
I've been handed a document consisting of 6 pages called Written Plea of Guilty. You probably went over this document with your attorney before we started the hearing, is that correct?
Yes.
And did you read this document?
Yes.
Do you understand it?
Yes.
Did you discuss this document with your attorney?
Yes.
Did he answer all of your questions to your satisfaction about the document?
Yes.
Do you agree with what the document says?
Yes.
And do you wish to sign it?
Yes.
I'm going to go over the charges you are proposing to plead guilty to so that we are all on the same page. Count 1 says that on August 10th, 2022, in the city of Wickliffe in Lake County, Ohio, you knowingly obtained, possessed, or used cocaine, a Schedule II controlled substance, the amount of cocaine equaling or exceeding 27 grams, but being less than 100 grams. Namely, it was 51.74 grams. That's called possession of cocaine. It's a felony of the 1st degree. It's in violation of Revised Code Section 2925.11a. It is a Senate Bill 201 qualifying offense for an indefinite prison term, and prison is mandatory upon conviction. Do you understand that charge?
Yes.
And is that the first charge to which you wish to plead guilty in this case?
Yes.
Count 2 says that on August 10th, 2022, in the city of Wickliffe, Lake County, Ohio, you, not having been relieved from disability under operation of law or legal process, knowingly had a firearm, and you were either previously convicted of a felony offense of violence, namely attempted murder, felonious assault, and improperly discharging a firearm at or into a habitation or school in the Cuyahoga County Court of Common Pleas, case number CR 095212333B, on October 1st, 2009, or you are under, or you're currently charged with something that qualifies that, but that's not written in there. So you have a previous conviction for a felony offense of violence. That's called having weapons while under disability. It's a felony of the 3rd degree. It's in violation of Revised Code Section 2923.13A2. Do you understand that charge?
Yes.
And is that the second and final charge to which you wish to plead guilty in this case?
Yes.
You understand if you plead guilty to these charges, you are admitting you committed the crimes.
Yes.
You understand that if you had any defenses to the charges, you give up those defenses by pleading guilty.
Yes.
You understand by pleading guilty, you are giving the court the power to sentence you immediately.
Yes.
You understand that any rulings previously made by this or any other court on this case prior to this moment would not be appealable because you're pleading guilty now.
Yes.
And you understand that any claim of ineffective assistance of counsel, meaning that your attorney did not perform as a reasonably competent attorney, cannot be made on the basis of his services or performance rendered before today.
Say that again?
Because you're pleading guilty, you can't claim that your attorney has been ineffective in assisting you. You understand what I mean? That he did not perform as a reasonably competent attorney. In other words, if you have some complaint about your attorney and his performance, then I need to hear that before you plead guilty.
I understand.
All right? You have no complaints, correct?
No complaint.
And so that means that if I accept your plea of guilty, you can't complain about anything that he has done as being incompetent or ineffective up to the point where I accept your plea. You understand that?
Yes.
Now, that's not saying you can still raise the issue if he screws up during sentencing. You know what I mean?
Mm-hmm.
But as of this point, you're perfectly satisfied with his representation, correct?
Yes.
You have no complaints, and therefore you cannot make any complaints later on up to his services performed up to this point. You understand that?
Yes.
And you understand that although these crimes were alleged to be committed on the same day, probably at around the same time, or in conjunction with each other, you're pleading guilty to both. I can find you guilty of both, give you a sentence on both, and make those sentences consecutive with one another. Do you understand that?
Yeah, I understand.
Meaning they don't merge just because they were done at the same time.
I understand.
You understand that? And you understand what consecutive means?
Yes.
One run right after another, not concurrent, but consecutive. You understand
Yeah, I know.
that? So you understand that you are pleading guilty to one offense, count one, that requires that the court impose an indefinite sentence.
Yes.
And you're also pleading to a felony 3, and that the felony 3 carries a definite sentence. You understand that?
Yes.
And because one of the offenses is a qualifying felony 1, I must still impose the indefinite sentence as well as the definite sentence on the felony 3.
Yes.
You understand that? And you understand that on the felony 1, you will receive a minimum term and a maximum term.
Yes.
And the minimum term comes from the range of permissible sentences on the F1. That range is 3, 4, 5, 6, 7, 8, 9, 10, or 11 years. That's the minimum term. You understand that?
Yes.
And you understand I have to pick one of those, and whichever one I pick, the law automatically sets the maximum term of 1/2 of that. You understand that?
Yes.
And that on the F3, I pick a definite term of 9 months. These are all stated in months. 9, 12, 18, 24, 30, or 36 months. You understand that?
Yes.
And then I have to determine whether the sentence on counts 1 and 2 are concurrent or consecutive. You understand that?
Yes.
And you understand that if I gave you the longest minimum sentence on the F1, that would be 11 years. Following me so far?
Yes.
You have to verbalize because the recorder is going.
Yes.
And you understand that if I picked 11 years, half of 11, 5.5, add that to the 11. So if I give you the longest minimum sentence, which would be 11 years, the longest maximum sentence would be 16.5 years.
Yes.
And you understand that if I gave you the longest definite term on the weapons under disability of 36 months, I'll make it 3 years just to keep it years to years, and I made that consecutive, then your longest minimum would be 11 plus 3, or 14, and the longest maximum would be 16.5 plus 3, or 19.5 years.
Yes.
So you understand that if everything in your life goes wrong, and I give you the longest of everything, and you screw up in prison, and you get the longest, they hold you for the longest period of time, the absolute maximum that you would do for the crimes on this case would be 19.5 years.
Yes.
And you understand that on the fines, that on count 1, there is a minimum mandatory fine of $10,000 and a maximum mandatory fine of $20,000.
Yes.
And you understand that on the weapons under disability, there is a discretionary fine of up to $10,000.
Yes.
And if I made the fines consecutive at the maximum level, then the maximum fines would be 20 plus 10, or $30,000.
Yes.
Go ahead, complete your thought. Follow me so far?
Yes.
No questions at all as
No.
to the length of prison and fines?
No.
So,
If I may, Your Honor. We get page 3 of 6. Middle of the page, when it starts talking about the fine. Some language in this form. Unless the court finds that I'm in these two persons. You see that language, Your Honor? Upon the court's review of an affidavit of immediate that may file prior to the sentence.
yes.
Okay. I don't know that that's in every form that's ever come before the court, so I wanted to highlight that, and that might have been where some of that questioning was about this fine.
It is, it is, Your Honor, if only because I talked to my client about asking for the court's consideration as to indigency based on his current financial status, but I thought this was a little ahead of the cart before the horse, if you will. We probably need to enter the plea first, we can handle that. And then, again, as I understood it, I should file this before sentencing, if I'm not mistaken.
That's what it says.
Yeah, I mean, that's how I understood it, but we had talked about this, and that was a point of confusion, as well as the Reagan-Tokes issue is confused even some folks in your position, as well as many in mine at times. So, while we had talked about it and I'd explained it, nevertheless, I think it's probably something you need to hear more than once before it may actually take a hold on some level.
Okay.
And hearing the maximums, of course, again, are always the most upsetting and disturbing. Thank you, Judge.
Yeah, well, as with any case, when fines are mandatory, defense counsel knows that they can file affidavits of indigency and a motion to relieve the defendant of the fine, and I don't usually advise on that because if it exists, fine, and if it doesn't exist, I've prepared the defendant for the worst, and I don't want to have to spend the time of inquiring into finances and indigency.
Yes, Your Honor, I know. That's why I wanted to point that out to you, that that's in this particular form based on the conversations Mr. LaRue and I have had.
That's fine.
Thank you, Your Honor.
Thank you.
So, upon your release from prison, you would be on a mandatory period of post-release control for a minimum of 2 years up to a maximum of 5 years. Do you understand that?
Yes.
And under post-release control, you may be required to wear a GPS device.
Yes.
And under post-release control, if you were to violate the terms of it, the adult parole authority can return you to prison for up to 9 months for any one violation and up to 1/2 the original prison term I give you for all violations in the aggregate. All of that time is part of the sentence. Do you understand that?
Yes.
Further, if your violation of post-release control is a new felony, the judge in the new felony case, in addition to sending you to prison on the new case, can send you back to prison on this case for the greater of 1 year or whatever length of time remains unexpired on that mandatory period of post-release control, and all of that time is already part of the sentence. Do you understand that?
Yes.
Now, as far as the release date goes, regardless of whether you receive any kind of good time credit, you would be released when you finish the minimum term I give you, unless the Department of Rehabilitation and Correction, I'm just going to call it the DRC, determines that you must remain in prison for bad conduct.
Yes.
So in other words, your expected but not guaranteed release date from prison is at the end of the aggregate minimum term after serving any mandatory prison and less any jail time or earned reduction credit. You understand that?
Yes.
And you understand that the DRC can rebut that presumption if at a hearing held within the walls of the prison, the DRC determines that there are certain factors or events that have occurred regarding your conduct while confined, your rehabilitation, your threat to society, your restrictive housing, if any, while confined, and your security classification warrant them to keep you longer. You understand that?
Good.
And so I have to give you what is that criteria so that you understand that before you actually go to prison. So the presumptive release date is at the end of the aggregate minimum term after serving any mandatory prison, less any jail time credit, which you're earning right now, presumably. I don't know if you're in on something else or just this. The presumptive release date is rebuttable if you commit institutional rule infractions that compromise prison security or threaten the safety of prison staff or inmates, or you commit a violation of law that was not prosecuted, and the infractions or violations show that you have not been rehabilitated, or by your conduct you show that you continue to pose a threat to society, or if you've been placed by the DRC in extended restrictive housing at any time within the year preceding the date of your release hearing, or if you're classified by the DRC as a security level 3, 4, or 5, or at a higher security level, then your release date would be up to the aggregate maximum term. You understand that?
Yes.
Court's not involved in that decision. You understand that?
Yes.
And if the department, the DRC, at the hearing makes the specified determinations and rebuts the presumption of your release, the department can maintain your incarceration after the expiration of that minimum term or any other extension of that minimum term for the period of time the department determines to be reasonable, subject to when that tail, that 50% period, is up. They have to release you no matter what. You understand that?
Yes.
So they can do that over and over again multiple times, but they do have to release you when that 50% of the minimum term on count 1 expires.
Yes.
Now, there are certain credits that may be available. There is, you went to 10th grade?
Yes.
Okay. So you may be eligible for what's called the 8 or 10% credit, and that's awarded by engaging in programming offered to you for that purpose. It does not apply to mandatory prison terms, so it wouldn't apply to the F1 time, but if you're serving F2 time, the F3 time, it could apply to that. Do you understand that?
Yes.
Now, if I made the sentence concurrent, then it really wouldn't apply at all, because all your time would be mandatory time. So, the other type of credit is the 5 to 15% credit, and I'm mentioning the 8 to 10% and the 5 to 15% because they're out there, but I don't think they apply to yours because on count 1 it's mandatory time. And my understanding of the law is if the statute says the time is mandatory, neither of these credits apply, so that the only credit that does apply in your case would be jail time credit you're serving now. You understand that?
Yes.
But the 5 to 15% is a good time credit for exceptional conduct or adjustment to incarceration. I can't tell you what exceptional conduct is or adjustment to incarceration because I haven't seen any regulations drafted on that yet, and I don't know if anybody has encountered that yet since the law has been adopted. But the court's involved in that. The department has to request that hearing, and the hearing is conducted in court, not at the DRC. And there's an expectation that the court grants it, but there could be sufficient proof that rebuts that presumption that the court should grant it. I'm just talking a little bit about that to let you know that that's the type of credit that would be done by the court, and it's requested by the prison. It's not mandatory that the court grant it, and as with all that credit, I believe it's not applicable to someone with a mandatory prison term. However, it wouldn't be the first time that I saw the DRC do something that I thought they couldn't do. So I'm just pointing it out to you. There's no harm in asking about it once you get down to the institution. When it comes to judicial release, it doesn't include the mandatory terms. So with judicial release, you have to wait a certain period of time before you're eligible to apply. The mandatory time is not included in that. That has to be served first. You have to be into discretionary time before you can file. So, meaning if I made your sentence consecutive, the mandatory time gets served first, the discretionary time gets served second. You may be eligible for if I gave you a consecutive sentence.
Yes.
You understand that? You understand that you would forfeit any contraband and instrumentalities of the offense.
Yes.
That would be drugs, paraphernalia, anything of that sort.
Yes.
You understand that by pleading guilty, you are disqualified from purchasing, owning, possessing, or using firearms or ammunition for firearms. That's both state and federal.
Yes.
You understand you cannot vote from prison. In order to regain your ability to vote, you would have to re-register upon your release from prison. You cannot serve as a juror while in prison or on post-release control in any case where the state of Ohio is a party, because you would still have an active case with the state on the other side, and you cannot hold any position of public honor or trust. You understand that?
Yes.
You understand these crimes are not sealable or expungible.
Yes.
In addition to the fines that I mentioned, you understand I will order you to reimburse the government the cost of confinement, any supervision, any treatment, and court costs.
Say that again?
That I would order you to reimburse the government the cost of confinement, supervision, treatment, and court costs.
Yes.
And you understand the cost of confinement includes transportation costs between the court, the jail, and the prison.
Yes.
You understand I will enter a judgment against you for the costs of prosecution.
Yes.
You understand a failure to pay all fines and costs in full can result in the state blocking your motor vehicle license plates until they are paid in full.
Yes.
You understand all the potential penalties.
Yes.
Do you have any question at all as to what can happen to you as a result of your plea of guilty today? So, you understand that you don't have to plead guilty. You have a right to have a trial to determine whether you're guilty of any crime.
Yes.
You understand that trial would automatically be by a jury unless you decided you wanted a non-jury trial. A non-jury trial is a trial where you want the judge not only to make all of the decisions throughout the case, but you want the judge to make the ultimate factual determination in the case whether the state can prove you're guilty beyond a reasonable doubt. You understand that?
Yes.
You understand that a trial gives you the ability to test every aspect of the state's case, both factual and legal.
Yes.
You understand that with the jury trial, the jury makes the decision. I don't, whether the state has proved its case against you. Furthermore, it takes all 12 jurors to agree that you're guilty before it's even possible for you to be convicted. You understand that?
Yes.
The state of Ohio is required to prove you're guilty beyond a reasonable doubt. If the state failed to prove even one essential element of a particular charge beyond a reasonable doubt, you could not be convicted of that particular crime. Your plea of guilty provides the court the entire factual and legal basis upon which to convict you and sentence you, and by your plea, you are relieving the state of any obligation to prove anything, let alone prove it beyond a reasonable doubt. Do you understand that?
Yes.
You have the right to confront your accusers, meaning to have your attorney question all of the state's witnesses under oath in front of the judge and jury. Do you understand that?
Yes.
You have the right to use the subpoena power of the court to compel witnesses you need to come here to testify for you, especially witnesses who are reluctant to come to court, out of state, or incarcerated someplace. I can get them here for you. Do you understand that?
Yes.
You have the right to tell your side of what occurred here and testify in your own defense. Or you can refuse to testify. It's one way or the other, but it is your choice. No one can compel you to testify if you did not want to, and if you chose not to testify, that could not be used against you to prove that you were guilty. In fact, the prosecutor could not even comment on your silence to infer you might be guilty, have something to hide, maybe have a prior conviction. The jurors would be told you have the constitutional right not to take the stand and testify. We would select only individuals to serve as jurors in your case who answer under oath during jury selection, but they will uphold that right. You understand all of that?
Yes.
You understand that if you were not pleading guilty today, you would always be represented by an attorney at law throughout this case, free of charge to you if you could not afford counsel. You understand that?
Yes.
You understand that if you were not pleading guilty today, you could appeal any of the decisions I would make throughout the case. You could appeal the jury's verdict. You would have a transcript typed up of everything that was said or done in this court, so you can demonstrate it to a higher court any mistakes made here to get those mistakes corrected, and an attorney to handle that appeal for you. And if you could not afford that, all of that would be provided to you free of charge, paid for by the taxpayers. You understand that?
Yes.
You understand a plea of guilty is a complete admission of guilt.
Yes.
You voluntarily give up all the rights that I just explained to you and wish to have this court accept your plea of guilty to count 1, possession of cocaine, felony 1, Senate Bill 201, qualifying offense with mandatory prison, and count 2, having weapons while under disability, felony 3.
Yes.
Are you now, or were you at the time of these offenses on August 10th of last year, on parole, post-release control, community control sanctions, or probation to any court anywhere?
Yes.
Tell me about that.
I just came out from jail. I was on PRC.
You were on PRC?
Yes.
And where did the sentence arise out of? What county?
Cuyahoga.
And what year?
2009.
And so that's what's mentioned on the weapons under disability?
I believe so.
So who was the sentencing judge?
Janet Burnside.
And how long did she give you?
13 years.
And when did you get out?
March 21st, 2022.
So you were on 5 years of PRC?
Yes.
And you used up maybe 4.5 months of it?
Yes.
And has the Ohio Adult Parole Authority placed a holder on you?
Yes.
And they haven't yet imposed a sanction?
No.
They want to see what I do first?
I believe so.
So you understand that when it comes time for sentencing, I can terminate your PRC and impose the balance of the PRC time. So roughly 4 years, 7.5 months that you would serve prior to and consecutive with whatever prison term I give you on this case. You understand that?
Yes.
Okay, you were a little slow saying yes on that. You understand that that's what can happen.
You saying you can give me the rest of my time in jail if I had on PRC?
As a sentencing judge in this case, even though I wasn't the sentencing judge on the other case, the law is that I can terminate your PRC and impose the balance of the time, and you would serve that time prior to and consecutive with whatever time I give you on this case, counts 1 and 2.
I understand.
You understand that?
Yes.
This isn't the first time you've heard that, correct? I'm sure your attorney would have told you that.
Yeah, I understand.
And you understand that if I don't do that, that the Department of Rehabilitation, the APA, can sanction you. And they can impose 6.5 years, half the original prison term I'm just going by what you said it was, 13 years.
Yeah.
You understand, they can impose 6.5 years and make that consecutive to the time that I'm giving you. You understand that?
Yes.
And there may be a third alternative out there. Is there a third alternative? That's the only two alternatives?
Not that I can think of.
It's the only two
I mean,
alternatives?
the other alternative is that you don't impose anything and they don't impose anything. That would be the third alternative.
I'll get a fourth one then.
Well,
That's the
in
one
which
that
case, the PRC time continues on until after you're released here, so that you will have guaranteed 4 years and 7.5 months of PRC time awaiting you at the end of this, rather than the 2 to 5 of PRC time that I mentioned to you. What's the fourth alternative?
Judge, I believe that the adult parole authority would not be required to give the maximum all the way up to half of the 13-year sentences. We're talking up to 6.5 years. They could give up to that. That's the maximum.
Yeah, they can give anything
They could
less than
give
that.
90 days. They could give 9 months. They could give 5 years, whatever. All I wanted to do is explain that there's sort of a range. He's just trying to.
Okay. And so, Mr. Jenkins, you understand that what the DRC does, I have no control over. I can only control what I do, and for my part, I can terminate PRC and impose the balance. Actually, I too can impose up to the balance, because I think there is some discretionary on my part where I don't have to give you the full maximum that could be due. You understand that?
Yes.
And one other thing, you don't get hit double on it, so that whatever sanction I do, or whatever sanction the DRC does, they won't duplicate. You get credit for the one against the other for the sanction. Correct on that?
I believe that's right.
That's as I understand it.
Okay. So, have you ever been to prison other than the one that Judge Burnside gave you?
No.
Do you have any other felony convictions on your record other than that one from 2009 out of Cuyahoga County?
No.
So you understand, by pleading guilty, you are voluntarily giving up your liberty for whatever length of time I sentence you to prison.
Yes.
So you understand, has anyone made any promises to you to plead guilty here, or any threats?
No.
And you understand no one has promised you what I do when it comes time for sentencing, because I don't even know, as I sit here, what I'll do. I need to see a pre-sentence investigation.
Yes.
And Mr. DePiro, has the state of Ohio promised Mr. Jenkins anything in this case?
Yes.
Other than the charges?
Well, that's the first thing. The state has agreed and promised to proceed by way of information on only the 2 charges that are contained in that information, and no...
He could have been charged with others?
Could have been also the firearm specification.
Oh, okay.
18 mufflers instead of 1. So we agreed to go forward without those specifications and no additional charges other than what's in the information. Also, Your Honor, the state has agreed, promised that the state would recommend a prison term of 8 years. on count one, being 8 to 12 years total. Actually, as to both counts, Your Honor. The state's not going to recommend more than 8. But it would be 8 years on count one, and then any prison, well, and there would be a prison term on count two, but the state would recommend it run concurrent. It would be 8, the minimum, and then the indefinite maximum up to 12. Also, Your Honor, the state has agreed to take no position on the imposition of a judicial sanction for the PRC violation as a result of this case.
Okay. So, Mr. Jenkins, did you hear and understand what the prosecutor just said?
Did.
Let me recap it. The prosecutor says that you received consideration for pleading to an information, meaning not going to trial, owning up to it.
Good.
They could have charged you with the possession of the firearm, which would add 18 months consecutive to whatever you got on count one. They're not charging you with that, but they say they could have charged you with it. And it's sort of obvious they could have, because you're pleading guilty to a weapons under disability. So I know you had a firearm with you. They could have charged the specification for 18 months on count one, and we know it's 18 months because you have the prior conviction. You understand that part so far?
Yes.
You understand that the state is also capping its recommendation at a minimum on count one at 8 years, so that they're not going to request 9, 10, or 11 years on count one. And further, anything they request on count three would be concurrent with count one, so that the state's maximum recommendation, if everything is as they already know it to be, and you don't commit a bond violation while in jail or another crime, they would be requesting a maximum of 8 to 12 years rather than 16 and a half to 19 and a half years.
Yes.
Has the state promised you anything else other than that?
No.
Has anyone else made any kind of promises or threats to you in order to get you to plead guilty?
No.
Are you entering this plea freely and voluntarily?
Yes.
Have you told your attorney everything you considered important in this case?
Yes.
You didn't hold back anything from him?
No.
Have you had enough time to discuss what you're doing in this case with your attorney?
Yes.
Although this may be your attorney's recommendation for you to plead guilty as charged, is this your own decision and voluntary act to do so?
Yes.
Has your attorney done everything you've asked him to do for you in this case?
Yes.
And are you completely satisfied with the legal representation provided by your attorney, Edward LaRue?
Yes.
Mr. DePiero, what would the facts show if the case went to trial?
Your Honor, the facts would show, let me see that information.
Oh, sorry.
That's all right. The facts would show that on August 10, 2022, in the city of Wickliffe, Lake County, Ohio, the defendant was a passenger in his mom's vehicle about 1 o'clock in the morning. His mother was driving. And Wickliffe police officer observed that the rear plate illumination light was out. So through the course of a traffic stop, officers found that underneath the driver's seat there was a total of 51.74 grams of cocaine, Schedule II controlled substance, and it was in 2 separate baggies. It was totaling 51.74 grams. The defendant admitted that he knew that cocaine was there and that it was actually his cocaine. Along with that cocaine, Underneath the seat, there is a firearm, Your Honor. It was loaded. It's operable. And this was a Taurus G2C 9mm semi-automatic pistol. The defendant contributed DNA that was found on a swab of that pistol. The DNA mixture profile that was on the swab of the pistol and the magazine from under the seat was 84.2 trillion times more likely to occur if the mixture consists of DNA from the defendant and two unidentified contributors. So in effect, it's his DNA on there. This is, the defendant has the prior conviction as enumerated on count 2, and the state would incorporate all the specifics of that prior conviction as read by Your Honor as contained typed in count 2, the 2009 felony conviction that the court's been asking the defendant. So as a prior offense of violence, he shouldn't have had it.
Jenkins, did you hear and understand everything the prosecutor just said?
Yes.
And is everything he said true?
Yes.
What is your plea to count 1, possession of cocaine, felony 1, a Senate Bill 201 qualifying offense for an indefinite prison term with mandatory prison?
Yes.
Your plea to count 2, having weapons while under disability, felony 3?
Yes.
I'm going to hand you that 6-page document, written plea of guilty, that we talked about earlier. Make sure you've read it. Make sure you understand what it says. Make sure you agree with what it says. And if you sign it, sign it only because that's what you want to do. And I've put a star on page 3 in front of the post-release control admonition because it does apply here. And I want to make sure that it was in the document and that you were properly advised about it. So, Ruth? And you'll sign in 2 places, page 6 and page 5.
Your Honor, the defendant, Mr. LaRue, and I have each and all signed the written plea of guilty and judgment entry form here. With court permission, I'll first to give that form, Your Honor.
Yes, sir. Court will also sign the written plea and make it part of the record in the case. Record should reflect that Deshaun and Jenkins was here with attorney Edward LaRue in open court. I informed Mr. Jenkins of all of his constitutional rights. He's made a knowing, intelligent, and voluntary waiver of those rights. I find he understands the nature of the charges, the effect of the pleas, as well as the maximum penalty which can be imposed. Finding it to be knowing, intelligent, and voluntary, I accept his pleas and find him guilty as charged. Count 1, possession of cocaine, felony 1, revised code 2925.11A, Senate Bill 201, qualifying offense for mandatory prison, and count 2, having weapons while under disability, a felony of the 3rd degree in violation of revised code section 2923.13A2. I'm going to refer you to the Lake County Adult Probation Department for a pre-sentence investigation and report, and a drug and alcohol evaluation with a brief mental assessment. Any other purposes for referral? Sentencing will be held in this court on Monday, March 20th, 2023 at 9:15 a.m. And Jenkins, who lives at 20951 Wilmore?
Mom.
Mother? And her phone number is the 0886?
Yeah.
What was bond set at
No bond.
previously?
The municipal court level, Your Honor, it just says no bond.
Okay. I will continue that.
Thank you, Your Honor.
And I'm printing out the referral. Probation department will talk to you over at the jail. And is there anything further from the state?
Yes, Your Honor. Does the court order the prosecutor's office to prepare the document?
Yeah, the court orders prosecutor to prepare the entry.
Thank you, Your Honor.
Okay, Mr. LaRue, anything further?
No, Your Honor.
Okay, well, I won't see you on March 20th.
Not unless we cross paths otherwise.
Yeah.
Good luck, Judge.
There'll be another judge sentencing.
Yep. Thank you, Your Honor.
Thanks, Judge.
Take care.
All rise.
Clerk.
Run record. This is case number 21CR001296, State of Ohio versus William D. Howard. Mr. Howard is in court, represented by counsel. Attorney Matt Bangerter, representing the State of Ohio, is Assistant Prosecuting Attorney Taylor Linden. The defendant was here on September 6th, 2022. He pled guilty to count 1, felonious assault, a felony of the second degree, a Senate Bill 201, qualifying offense for an indefinite prison term, and count 2, assault, a misdemeanor of the first degree. Count 3 will be dismissed upon completion of sentencing. I referred the defendant to the Lake County Adult Probation Department for a pre-sentence investigation and report and victim impact statements, and set sentencing for October 17th, 2022. I continued his bond. When we convened on October 17th, I had not received a victim impact statement and was concerned about that, so I continued the matter to get the victim impact statement that was requested on September 6th, 2022, but had not been returned. It was returned on December 30th, 2022, so I do have a victim impact statement. I also have a pre-sentence report prepared by the Lake County Adult Probation Department dated September 26th, 2022. 9 letters of support on behalf of the defendant, which I received this afternoon. A report from Dr. Rinsberg, drug and alcohol, with a brief mental assessment dated September 29th, 2022. I have read these documents. I will make them part of the record. Any inaccuracies, any modifications needed?
No, Your Honor.
Any reason not to proceed to sentencing?
No, Your Honor.
You may address the court first.
Thank you, Your Honor. We were asking the court to impose a sentence of community control on Billy. We believe that community control would adequately punish him and protect the public. He still, of course, can have local jail time. He can be incarcerated. He can be fined. He can be sent to, he's already doing anger management, sent to any counseling the court wishes. And he's still under probation, so if he does screw up, we have 2 to basically 12 years hanging over his head to protect the public from any possible future incidents. But I would say as far as the factors, recidivism factors, he's showing a great deal of remorse, is what I can say. He's genuinely torn up about what happened. Although he does have a past history. He has not gotten in any trouble since this incident, which was now almost 3 years ago. He is in a different place in life from several years ago when he was homeless, addicted to drugs, to being off drugs, in a rent-to-own agreement to buy his first house, engaged, and with a new daughter that's happened since this case appeared. So he's in a very different spot, which makes recidivism far less likely. We'd also say that it wouldn't demean the seriousness of this offense. He is, when we look at the seriousness factors, the only factor that makes it more serious is the injury suffered by Mr. Finley. It certainly was a serious injury, but on the other side, Billy didn't go out there expecting to really hurt someone like this. And it's not a case where he jumped someone behind the bar in an alley or he's going to hurt someone. As he describes it, it was 20 or 30 people in sort of a mosh pit situation. So I picture a typical TV bar fight. Not a great situation. Certainly, he's responsible, but it's also not as serious as someone who attacks with a deadly weapon or with intent to maim or kill. And there are grounds to, I think, to mitigate his behavior. With one, is how far he's come. He's been doing anger management. He goes to counseling once a week. He has a new family. Fatherhood has made him a changed man. And last but certainly not least, is my understanding that Mr. Finley himself does not want Billy to go to prison, for which we are incredibly grateful for that forgiveness on his part. Billy does have great family support now. Like I said, besides his fiance, he has other family here in the courtroom to support him. So he's not in a place in his life where he's going to be getting back into this kind of trouble again.
William Howard, the law allows you to say whatever it is you want me to consider. Before I sentence you, what do you want me to know?
I wrote a letter. Oh, sorry. I wrote a letter. If I can read that real quick.
Go ahead.
Dear Honorable Judge Lucci, I just want to start off by saying that for having even stand, I'm sorry for even having to stand in front of you again. To the victims of the event that took place, I truly am sorry, and I take full responsibility of the actions on that night. And if they were here, I was going to ask you if I could talk to them, but I know it's hard to forgive, but if you can find in your heart to, for I am not the same person that I was. I have changed so much in the last 4 years. Drugs and alcohol are no part of my life. The last time I was in front of you, I was on drugs, alcohol daily. I was hopeless, jobless. Today I speak that I've done a complete 180 in my life. I have a full-time job, a car, buying a house, added a beautiful fiance and a gorgeous 6-month-old daughter. They are my world, and my purpose in life is to provide for them. I promise you never here to see me in another courtroom. Thank you for your time.
Do you have any witnesses to present?
I'm sorry?
Do you have any witnesses to present?
No, Your Honor.
We'll hear from the state.
Thank you, Your Honor. Your Honor, and first of all, thank you for continuing the hearing to allow for Mr. Finley to then present his victim impact statement. I've had a lot of contact with him over the course of the last year and a half. And when we sat down and we talked about this, one of the things that I don't know, I think the word that was used is gracious. I think a lot of it is that for Mr. Finley, he realizes that he's made some of his own mistakes in his life and that he didn't want this to necessarily ruin the defendant's life based on the fact that he had a daughter. Now, quite frankly, these are really serious injuries. In terms of speaking to Mr. Finley, at first, being punched in the throat, I don't think he really realized how severe it was until the next day when his whole throat was swollen and he had to go into the ER. As the court is aware, he did have a fractured larynx, and it was difficult to repair. And one of the doctors did indicate that this is the kind of injury that you normally see on someone who's deceased. So he is very lucky, and I know that he acknowledges that he's very lucky as a result of what happened. And I think part of the issue is that the defendant doesn't know his own strength or didn't know his own strength. And I don't know that it was quite the melee that it was made out to be, but certainly when you have a bar fight, there's alcohol, sometimes there's drugs, and eventually it ends up in some kind of a fight between individuals. Unfortunately, Mr. Finley was in the middle of that, and then Mr. Morgan was as well. So in my conversations with Mr. Finley, one of the things he did say is that he is not opposed to him being on community control. I think part of our conversation had to do with the fact that if he's really changed as much as he says he has changed, that time will remain hanging over his head. But if he proves that he can't do that, then it's on him that he's going to prison as a result of it. So in speaking to Mr. Finley, and my understanding is that the original amount that we thought was $5,000 for the restitution, but apparently there is $1,483.74 of the deductible that he actually had to pay. There were collections against him, and they weren't able to collect the balance of that, so that was written off. So the restitution to Mr. Finley would be $1,483.74. So we would ask that be imposed. The factors under 29-29-12, B, C, D, and E, there is obviously serious physical harm that resulted here. And in the recidivism factors, there were prior sanctions. He didn't respond favorably to that. There were drugs and or alcohol involved here. And there is that history with the prior prison. The prior aggravated assault was a situation that happened at the Great Lakes Mall, this one being at a bar. We do believe that there are consequences that are necessary, and so jail time is requested. I know that he's going through anger management. We believe that should continue with any other mental health counseling that's necessary. While in the Lake County Jail, we would ask that he go through jail treatment program while he's there because this offense involved alcohol. I know that, I believe it was in Chambers, there was the last use of marijuana was quite some time ago, but because both of the incidents that he's been involved in have to do with drugs and or alcohol, we would ask that be addressed, along with a no contact order with Mr. Finley and Mr. Morgan. Thank you.
What's the credit?
2 days, Your Honor.
I've considered the record, oral statements made, victim impact, pre-sentence report, drug and alcohol and psychological evaluations, my conference in chambers with counsel and probation, and the statements of the defendant and the defendant's counsel. I've also considered the overriding purposes of felony sentencing, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender and promote the effective rehabilitation of the offender using the minimum sanctions that the court determines accomplish those purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution along with the public burden. I've considered the joint recommendation of the parties for a community control sanction. I have reasonably calculated the sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society and the victim, and to be consistent with sentences imposed for similar crimes committed by similar offenders. In using my discretion to determine the most effective way to comply with the purposes and principles of sentencing. I have considered all relevant factors, including the seriousness and the recidivism factors set forth in the statute. In that regard, the sheer physical harm suffered by the victim, Charles Finley, makes count 1, felonious assault, more serious than what would be expected. There are no factors making the offenses less serious. In terms of recidivism, there are factors making recidivism likely. The defendant does have a previous criminal history with two prior assaultive conduct, including the one that I sent the defendant to prison, aggravated assault F4 in 2018, and I placed the defendant on community control first and tolerated several probation violations before I sent him to prison. There's been a rehabilitation failure after previous convictions, a failure to respond in the past to community control, a pattern of substance abuse, and the offender refused to acknowledge a problem or accept treatment or apply treatment tools given to him. His Ohio Risk Assessment score is squarely in the moderate range of 24. In terms of making recidivism less likely, the offender is genuinely remorseful and has been clean and sober. And has structure to his life, employment, and family. The court determines that prison is not needed to protect the public from future crime, and the court will adopt the joint recommendation for community control. The court does note there's no merger here between the two counts. The court hereby imposes a period of community control for 2 years, each count concurrent, subject to the general supervision and control of the Lake County Adult Probation Department under such terms and conditions that it finds appropriate. Among these, you shall not leave the state of Ohio without the permission of the court, and you shall abide by all laws, including but not limited to the laws related to firearms, deadly weapons, and dangerous ordnance. The court further imposes the following specific sanctions and conditions. On count 2, the misdemeanor, a period of incarceration in the Lake County Jail for 60 days with credit for 2 days already served. The latter 30 of which you shall enter participating and successfully complete the jail treatment program and follow all aftercare recommendations. On count 1, the felony 2, 2 days in jail, credit for 2 days, concurrent with count 1. Count 3 is dismissed. And on count 1, you'll follow the aftercare recommendations of the jail treatment program, which is being served on count 2. You could have complete abstinence from alcohol and drugs of abuse, periodic screens to monitor your compliance, full-time employment or school or combination of employment and school, but outside of any establishments that sell alcohol or drugs. What is your marital status?
Fiance.
Fiance?
Yes, sir.
Was she with you when this occurred? Who was with you when this occurred?
I didn't have a significant other.
Okay, you're not permitted into any liquor establishments for 1 year unaccompanied by either a adult relative or close adult friend. You can understand why I'm ordering that.
Yes, sir.
Okay, somebody to give you a reality check, slap you around and say, what the hell are you doing? Pursuant to 29.18, the court determines that you have or will have the ability to pay restitution and a financial sanction. Court orders restitution in the amount of $1,483.74 to the victim, Charles Finley. Judgment rendered for that amount to be paid in full at least 60 days prior to the expiration of the stated period of community control, and I'm fining you $1,000. You'll take all medicines as prescribed and perform 50 hours of community service. You're to have no contact with either or both of the victims. You're to complete anger management counseling and follow all recommendations. You'll pay the costs of prosecution, confinement, community supervision, treatment, and court costs. Any violation will result in a prison term on count 1 of 8 to 12 years. You're further reminded that if you do end up in prison, post-release control is mandatory for a minimum of 18 months to 3 years. They can return you administratively for any violation, for up to 9 months for any one violation, and up to 1/2 the original prison term I give you for all violations in the aggregate. All of that time is part of the sentence. Should the violation of post-release control be a new felony, in addition to going to prison on the new case, you can go back to prison on this case for the greater of 1 year, or whatever length of time remains unexpired on the mandatory period of post-release control, and all of that time is part of the sentence. When I took your plea, I explained the 8 or 10% credit and the 5 to 15% credit. And I also explained that you may substitute community service for the costs of prosecution, working it off at the rate of $10 per hour. Each hour of work performed reduces the judgment by that amount. That's in addition to the 50 hours I ordered as part of the sentence, community service. So long as you owe any fine or cost, the state can block your motor vehicle license plates until they are paid in full. Bond is released. Is there anything further from the state?
Your Honor, just in terms of doing the entries, you have the state do the
The
entry?
state's to prepare the entry, but I want a copy, so if I have any changes to be made, I can make those changes directly and file it.
Thank you, Your Honor.
And we just copy Mr. Bangberger on what you send me as the draft. Anger?
Nothing else, Your Honor, thank you.
Probation? All right, good luck. This is the second time, something like this. You gotta get your emotions and your anger in check. 3 strikes and you're out.
Yes, sir.
All right, good luck.
Thank you, Your Honor.